Hearing will come to order. Today we have 5 judicial nominees and 1 nominee to the Department of Justice. Myrna Perez, nominated to the Second Circuit. Judge Sarah Miriam, nominated to the District of Connecticut. Judge Karen Williams, nominated to the District of New Jersey. 2 nominees to the D.C. District Court, Gia Cobb and Judge Florence Pan. And Matt Olson, nominated to serve as Assistant AG for the Justice Department's National Security Division. A number of our colleagues will formally introduce the nominees, but I'd like to make a few observations. First, with these nominees, the Biden administration and the Senate continue to bring diversity and professional balance to the bench. Today's slate includes Myrna Perez, who will be the first Latina to serve on the Second Circuit since Justice Sonia Sotomayor. We will also hear from Florence Pan, who will be the first Asian American woman to serve on the D.C. District Court. The slate also includes professional diversity. We have 2 sitting federal magistrate judges, a judge of the D.C. Superior Court, who was previously an assistant U.S. attorney, and a former D.C. public defender. And in Mr. Olson, we have an accomplished national security expert who spent decades working to protect America from enemies foreign and domestic. We have a civil rights champion in Ms. Perez, who's devoted her career to protecting and defending America's right to vote. It is a fitting time for her to join the bench, particularly after late rulings by the Supreme Court. I won't go into detail here in an effort to make sure that we get to the nominees as quickly as possible. But make no mistake, voting rights are a major issue and will continue to be for some time. I'm thankful for President Biden in putting forward nominees like Ms. Perez, who have such extensive experience. She has an impressive career as a litigator and an advocate, and an incredible insight into the impacts that restricted voting laws have on minorities. This type of legal experience is underrepresented on the court, and it's rare to see a voting rights attorney nominated to the federal bench. This perspective will bring diversity to our courts. Ms. Perez's record shows she's driven by her dedication to serving others and the Constitution. Before turning over to Ranking Member Grassley, I'd like to introduce 2 of the District Court nominees. Eleanor Holmes Norton was unable to make it this morning. Gia Cobb and Judge Florence Pan, both nominated to the D.C. Circuit District Court. Both of these nominees have her support, and she submitted statements for the record. I'm privileged to introduce Ms. Cobb this morning. Not only is she an excellent nominee, but she is an honorary Illinoisan, having attended college at Northwestern and then clerked in Chicago for my friend Judge Diane Wood on the Seventh Circuit. After graduating Harvard Law, clerking for Judge Wood, Ms. Cobb began her career in D.C. as a public defender, representing indigent defendants charged with criminal offenses. For the past 9 years, she has worked as at the national civil rights firm Relman & Colfax, representing plaintiffs in fair housing, disability rights, and employment discrimination claims. Ms. Cobb's extensive courtroom experience has undoubtedly prepared her for roles that await her on the U.S. District Court for the District of Columbia. In the past 15 years, and this is remarkable, anyone who's practicing law today will know it is, Ms. Cobb has tried more than 30 cases to verdict, both criminal and civil, and during her 6 years as public defender, she handled more than 200 cases and appeared in the court almost daily. It's an incredible record, and I wish we could look to that for every nominee who's coming before us. Having represented both sides in the courtroom, she understands that she needs to be a voice in our nation's court so that the law is applied even-handedly. Next, I'll introduce Judge Florence Pan, also nominated to the D.C. Court here in D.C. After graduating summa cum laude with 2 bachelor's degrees from the University of Pennsylvania, Judge Pan received her law degree with distinction from Stanford. Then clerked for Judge Michael Mukasey, well known to this committee, on the U.S. District Court for the Southern District of New York, and Judge Ralph Winter on the Second Circuit. Before her appointment to the D.C. Superior Court, Judge Pan spent her entire legal career in public service. She was selected for the prestigious Bristow Fellowship in the Office of the Solicitor General. She was an attorney in the appellate section of the Criminal Division at the Justice Department and a senior advisor in the Treasury Department. Finally, she served as Assistant U.S. Attorney for the District of Columbia for a decade, litigating local and federal courts at the trial and appellate level. In 2009, President Obama nominated her to serve on the D.C. Superior Court. She was confirmed by a voice vote. She was also nominated to the D.C. District Court by President Obama and favorably reported out of this committee by a voice vote in 2016. However, the majority leader at the time refused to hold a floor vote on her nomination before the end of the 114th Congress. Upon confirmation, Judge Pan would become the first Asian American woman to serve on the District Court for the District of Columbia. With that, I turn to my colleague, Senator Grassley.
Congratulations to all the nominees. I'll start by addressing the nominee of Myrna Perez for the Second Circuit, New York. Ms. Perez is a civil rights lawyer focused on voting rights. I think it's good for the president to look beyond the usual talent pools in picking judges. President Trump, for example, nominated a number of civil rights lawyers to the federal bench. Judges like Kyle Duncan of Louisiana, Matt Kaczmarek in Texas, and Sarah Pitnick in Missouri were all civil rights lawyers for significant portions of their careers. Indeed, should Ms. Perez be confirmed to the Second Circuit, she'll join two other civil rights lawyers of color appointed by Trump, Michael Park and Steve Menashe. Judge Park, of course, led the fight to end racial discrimination in higher education, a fight that's unfortunately still ongoing. Judge Menashe, among other things, ended religious discrimination against historic black colleges at the Department of Education. I think we've seen the court benefit from this diverse perspective, and it all goes to show that civil rights can take many forms. Now that said, my Democrat colleagues all oppose those Trump civil rights lawyers. Perhaps Democrats didn't think the civil rights that they were fighting for. I think the more charitable interpretation is that Democrats disagreed with their judicial philosophy. Yes, they all protected civil rights, but they also believed in textualism and originalism. Ms. Perez seems to be of the opposite of that. A prominent opponent of voter integrity laws, Ms. Perez seems to be very committed to a living constitution. That obviously concerns me, and I hope to discuss this issue with her today. I'd also like to add one more thing about Ms. Perez. Last night, the committee received a supplement from her. It was an article she wrote, which the progressive Christian journal Sojourners had just published, entitled, quote, "The GOP campaign to make elections less free," end of quote. Ms. Perez says that this article was submitted before she was the nominee and that she did not see or approve the title of the article before it was published. I expect to have a number of written questions about this, but I would make a few points. First, given the content of the article and the timeline of Ms. Perez's nomination, it's very unlikely that Ms. Perez submitted this inflammatory article while under consideration for this seat. Second, while the authors typically don't choose their titles, I have to imagine Ms. Perez could have gotten Sojourners, which isn't the New Yorker or the Washington Post, to accommodate a title change that wouldn't be an insult to half of this committee. I'll also note that this article's outrageous subtitle, quote, "Voters are supposed to choose their politicians, not the other way around," was written by Ms. Perez. Third, regardless of when it was submitted, Ms. Perez is bound by the code of conduct as a judicial nominee, and it's hard to see how publishing this article as a nominee is consistent with Canon 5 of the Code of Conduct. As to the other nominees, Ms. Cobbs seems to have similar problems, having in the past called for interpreting statutes based upon their social histories other than their texts, and Judge Miriam seems to have had a highly partisan political career. On the other hand, I remember Judge Pan from her last time before the committee. She seems extremely well qualified for this position, being well acquainted with the challenges faced by the District of Columbia, both as a prosecutor and a local judge. Judge Williams also seems to be well qualified. Lastly, we have Mr. Olson. I think it's important that the National Security Division focus on protecting us from the security threats and not focus on domestic politics. I hope that Mr. Olson agrees with me on that. Thank you, Mr. Chairman.
Thank you very much, Senator Grassley. We have some introductions, and I note my colleague Senator Booker is here, and I believe you are prepared to introduce one of the nominees.
I am, Mr. Chairman. I know you all always get very excited when there is a New Jersey nominee. Always. And as does Ranking Member Grassley. I am excited. I think all of New Jersey is especially excited, especially around the city of Camden, New Jersey, that I have the opportunity to introduce one of President Biden's nominees to serve as a district judge on the United States District Court for the District of New Jersey, Karen Williams. Judge Williams is currently serving her second term as a United States magistrate judge, where she has handled thousands of cases and demonstrated her incredible skill as a jurist and her commitment to justice and law. She is, in many ways, through many eyes, a local hero. She is a light to many in our community as someone who is showing how to conduct yourself with professional excellence, with dignity, honor, and a deep empathy for all of humanity. As part of her many duties, including handling both criminal and civil cases, Judge Williams also presides over the District of New Jersey's Reentry Court. Renew Camden, which works to assist formerly incarcerated people with their reentry into the community, is yet another testimony that she is living what a great American author, another African-American woman, wrote, that we are each other's harvest, we are each other's business, we are each other's magnitude and bond. Judge Williams recognizes the bonds we have to each other, that love your neighbor does not have conditions. She lives a life of great magnitude. Judge Williams is ready to serve as a federal judge. She has experience, she has skill, she has qualifications, she has empathy, and she has a life that is a testimony to the qualities we want on the bench. The American Bar Association just recently unanimously rated her as well qualified to be a district judge. She has also the full-throated support of the New Jersey Bar Association, the Garden State Bar Association, and the Association of the Federal Bar of New Jersey. And when, God willing, she is confirmed, Judge Williams will be the first Black woman to serve as a United States District Court judge in the Camden, New Jersey Federal Courthouse. She is a trailblazer and a history maker, should she be confirmed. I am grateful for her commitment to the law. I'm grateful for her commitment to service. I am grateful for her commitment to her fellow humans. And I urge my colleagues to advance Judge Karen Williams' nomination to serve as a federal judge. I just want to take a moment, though, if I can, and I know I'm stepping out of my lane here, but President Biden's nominee to serve on the Second Circuit Court of Appeals, Myrna Perez, is an extraordinary candidate. I have read about her, and I just want to celebrate her presence here, and I'm grateful that she is someone who's been advocating tirelessly and relentlessly for our democracy's most sacred ideals, which are voting rights. I'm excited about her nomination, and I will vote in favor of her to be another federal circuit judge.
Thank you very much, Senator Booker. We are in a semi-awkward situation. This is the first time that we are officially gathering in person instead of zooming in our comments, which was extraordinarily convenient but disjointed in its presentation. We're trying to get everybody back in attendance. So some of the members are on their way, I am told, which leaves me in a situation where I could give a long speech, but I won't. And I hope my friend won't either. I don't think he will.
Would you like me to say more about Judge Williams?
I think you've really done a fine job.
Thank you.
Don't risk it. Senator Blumenthal is on the way?
Yes, as are other members.
Okay. So there you are. I think we'll just go ahead with Myrna Perez.
So we could have. Turn the mic on.
To the rescue, Senator Richard Blumenthal of Connecticut has arrived in time to say a few words about his nominee.
Thanks, Mr. Chairman, and thanks for giving me this opportunity. I'm enormously honored and proud to be introducing Sarah Merriam today. Sarah Merriam is the lawyer we all want to grow up to be after we graduate from the Yale Law School. And I say that as a dad of a daughter who has just graduated from the Yale Law School and would do well to emulate her extraordinary career in the law and in community service. Senator Murphy and I recommended Judge Merriam to the White House, and I am grateful to President Biden that he has agreed with our recommendation. She received her BA from Georgetown University in 1993 and her JD from the Yale Law School in 2000. I spent a good deal of my career, several decades, as a litigator in the federal courts, and I have a particular allegiance to the values and ethos of the very highest quality that we should be seeking, as well as diversity in our federal judiciary. Judge Merriam fulfills those qualifications and expectations and much, much more. Her work in the courtroom began long before she joined the bench. After graduating from Yale Law School, she clerked for 2 federal judges. Both I admire greatly, Judge Alvin Thompson in the District of Connecticut and Judge Thomas Meskel on the Second Circuit. She was in private practice. She became an assistant federal defender in the District of Connecticut from 2007 until she took the bench in 2015. And I am really just thrilled that federal prosecutors agree with Senator Murphy and myself. Their statement is in the record. So do members of the private bar. Their statements are in accord. And I will just say that Judge Merriam really embodies the highest ideals and traditions of our federal district court in Connecticut. As a former United States Attorney and Attorney General for our state, I'm very proud to recommend her to this committee. And thank you, Mr. Chairman.
Thanks, Senator Blumenthal. Senator Murphy?
Thank you very much, Mr. Chairman. I know you have a busy agenda ahead of you and a number of our colleagues who want to introduce the nominees. Let me just associate myself with the remarks of Senator Blumenthal. I don't know that you're going to see a nominee before this committee who has, I think, a more important breadth of experience in the legal field than Judge Merriam. She has been an advocate for working people. She has been a very capable lawyer in private practice. As mentioned, she spent the bulk of her career as a federal public defender, and now she has been a very well-regarded federal magistrate, someone who comes to this hearing with deep experience in the federal court system. So I think her resume and her testimony will speak for itself. I come to you today as someone who has known Judge Merriam for 20 years, both professionally and personally. I will tell you candidly that when I began my time in public service, Sarah was someone that modeled just a unique combination of joy and compassion, hard-headedness, common sense, that to me caused me to choose to pursue a life in the service of the people of Connecticut. All of us, I think, have one or two of those people that we were able to interact with early in our career that inspired us to decide to pursue a life in public. And Judge Miriam is one of those people for me. And so from a very personal standpoint, I am incredibly humbled to be able to stand here today and to recommend my friend, to recommend one of Connecticut's brightest legal minds to this committee. Lastly, I'm just so glad that she's here with many of her family members, that others are watching from home. As she will mention, they are a big part of the reason why she is here today. They are all good and close friends of mine, and so I welcome the extended Miriam family to this meeting today. So again, a busy meeting ahead of you. Very, very pleased to add my words of introduction to those of Senator Blumenthal.
Thanks, Senator Murphy. Senator Menendez.
Well, thank you, Mr. Chairman, Mr. Ranking Member, and distinguished members. It's my pleasure to join my colleague, Senator Booker, distinguished member of this committee, to introduce Karen Williams, an exceptionally qualified nominee for the U.S. District Court for the District of New Jersey, where she has served as a U.S. magistrate judge for more than a decade. If confirmed, she would be the first Senate-confirmed African-American federal judge to sit in the District of New Jersey's Camden Courthouse. Yet it is the breadth and diversity of her experience in the field of law that makes her such an incredibly strong nominee. Originally from Long Island, Judge Williams attended Penn State University on a track scholarship, and she's never looked back, and started out her career as a wage analyst at the New York University Medical Center. Then after her mother took a job managing labor relations for the Golden Nugget Casino in Atlantic City, she relocated to Egg Harbor Township and earned her J.D. from Temple University Beasley School of Law in Philadelphia, and she has called South Jersey home ever since. Prior to her appointment as a U.S. magistrate judge, she spent 17 years practicing employment and labor law at the firm of Jasinski and Williams. There, she defended workers' rights, negotiated collective bargaining agreements between unions and local municipalities, and led litigation before state and federal courts. In 1998, Judge Williams successfully argued on behalf of Atlantic City before the New Jersey Supreme Court in a case that affirmed the local fire department's ability to discipline a firefighter for hurling racial epithets at a police officer. Since her appointment as a U.S. magistrate judge in 2009, Judge Williams has displayed an unyielding commitment to the fair administration of justice, to equal rights under the law, to a deference to precedent, and to the safety of our communities. Indeed, two of the most notable cases she has presided over involve threats to public safety. One case concerning an individual accused of planning attacks on synagogues, and another involving a defendant who advocated for rioting and looting during protests against police brutality during the death of George Floyd. In addition, Judge Williams has also served as an adjunct professor at Rowan University, where her classes on law and justice have undoubtedly inspired many students to pursue the legal profession. Judge Williams may have been born in New York, but she represents the best of New Jersey. I have complete confidence in her judgment, her values, her intellect, and her capacity to serve as a U.S. District Court judge for the District of New Jersey. And as you know, Mr. Chairman, and I appreciate this committee and your leadership in dealing with the emergency of judicial vacancies that exist in New Jersey. It's been declared a national emergency. The committee has been moving through nominees. I urge the committee's support for her nomination as well to help us meet that challenge.
Thanks, Senator Menendez. And I might say to you and Senator Murphy, I know you have a busy schedule, and if you'd like to leave at this point, it's perfectly acceptable. We now turn to Senator Cardin from Maryland.
Thank you, Chairman Durbin and Ranking Member Grassley. Thank you for giving Senator Van Hollen and I the opportunity to introduce a proud Marylander, President Obama's nominee for President Biden's nominee for Assistant Attorney General for National Security Division. Mr. Matt Olson is a proud Marylander. He hails from Kensington, which is also the home of our distinguished senator, Senator Van Hollen, and we're very proud of his appointment. Matt Olson has tremendous experience at the intersection of law enforcement and intelligence community at exactly the point where the National Security Division straddles these two distinct government functions. Mr. Olson has nearly 2 decades of experience in a wide variety of roles at the justice and intelligence community. Mr. Olson received his BA from the University of Virginia and his JD from Harvard Law School. He served as the judicial law clerk for the Honorable Norma Holloway Johnson, the first black woman to serve on the D.C. Circuit. Judge Holloway became Mr. Olson's lifelong mentor. After completing his clerkship, he joined the Justice Department's Civil Rights Division, where he enforced the Voting Rights Act. He also joined the U.S. Attorney's Office for the District of Columbia, where he supervised the investigation and prosecution of domestic terrorism, espionage, and export violation cases. Mr. Olson has prosecuted homicide cases, RICO cases, and drug and gang-related offenses. I understand that it was Mr. Olson's work as a U.S. attorney that led him to serve as special counsel to then FBI Director Mueller, where he supported the FBI's national security and counterterrorism work. After departing the U.S. Attorney's Office and the FBI, Mr. Olson helped create the National Security Division and served as one of its first officials as both acting Assistant Attorney General and a Deputy Assistant Attorney General. He oversaw 125 career professionals and managed intelligence and surveillance operations and oversight activities. In this role, he worked closely with the intelligence community. As the National Security Division, Mr. Olson led the Justice Department's participation in the interagency Guantanamo Review Task Force created by President Obama to evaluate the status of individuals detained at Gitmo Bay, which, as we all know, is an extremely difficult assignment. In 2010, he was appointed as General Counsel to the National Security Agency, which is headquartered in Fort Meade in Maryland. At NSA's Chief Legal Officer, he played a critical role in supporting the agency's operation mission. Mr. Chairman, I could go on and on. He has incredible experience in the intelligence community, in justice and law enforcement. He has the whole package. I want to thank him for his willingness to continue to serve the public and thank his family for their willingness to allow him to continue. I'm very proud to recommend his nomination to this committee, and I urge you to consider his nomination. Thank you, Mr. Chairman.
Thanks, Senator Cardin. Senator Van Hollen.
Thank you, Chairman Durbin, Ranking Member Grassley, members of this distinguished committee. I'm very proud to have the opportunity to also join my colleague, Senator Cardin, in introducing the President's nomination to serve as Assistant Attorney General for National Security at the Justice Department, Matt Olson, and would like to also welcome his family, his wife Fern, and their 3 children, Elizabeth, Nate, and Will, who are here today. President Biden has selected wisely in picking a nominee who has the experience, the expertise, and the sound judgment for this very important position. And he has very wisely selected a Marylander as well. I'm not going to cover all the details because Senator Cardin went over his very distinguished career, but I would point out that he has 20 years of experience in exactly the relevant areas for the position for which he's been nominated: national security, counterterrorism, and civil rights. I do want to highlight a couple of the areas where he served, including the Department of Justice, first in the Civil Rights Division, and then as Acting Assistant Secretary for National Security, where Senator Cardin said he helped establish the National Security Division at DOJ. His service as General Counsel at the National Security Agency, covering issues like cybersecurity and surveillance law, will also prove very important in his new position if confirmed. His most recent government post, Mr. Olson served as the director of the National Counterterrorism Center, where he worked tirelessly at the helm of the nation's efforts to combat terrorism at home and abroad by integrating terrorism intelligence and connecting the dots to deter, detect, and disrupt terrorist plots. In short, his work has helped save American lives. Each of these experiences prepare him very well for the skills that he will need to serve in this role. And there is no question in my mind, members of the committee, that Matt Olson is ready to take on the important responsibilities as Assistant AG for National Security. I was delighted to see that just yesterday, 80 former senior officials of the United States Department of Justice who have served under administrations of both parties wrote to this committee expressing their, quote, unqualified and enthusiastic support for Mr. Olson's nomination. On a personal note, I can testify to Matt Olson's good character because I also know him as a good neighbor in Kensington, Maryland. My wife, Catherine, and I frequently encounter Matt, Fern, and their children walking in the neighborhood, and the only family member who is not with them today is their dog, Kenai, who is a playmate of our dog. Chairman Durbin, Ranking Member Grassley, members of this committee, I am absolutely confident that if confirmed, Matt Olson will serve our country with honor and distinction, and I urge you to support his nomination for this important post.
Thank you very much, Senator Van Hollen, and I thank both you and Senator Cardin, and of course you can go about your business if you wish. We'll continue here. We are going to pause momentarily, waiting for the arrival of Senator Schumer, who's going to introduce the nominee for the first panel, so if everyone would please relax. Welcome, Senator Schumer. The floor is yours.
Thank you, Mr. Chairman. And I want to thank you and my colleagues on the Senate Judiciary Committee. It's always a pleasure to be back here, where I served many happy years. In fact, if you add up my time on the House Judiciary Committee and the Senate Judiciary Committee, it's 1982 to 2016. It's a lot of years. So it's glad to be back. And it's particularly glad to be back for the reason I'm here today. It's my honor, my true honor, to introduce a nominee to the committee for the Second Circuit of New York, Myrna Perez, an experienced litigator, one of the foremost election lawyers in the country, whom I was so proud to recommend to President Biden. Myrna Perez's life is a quintessentially American story. The daughter of Mexican immigrants, Myrna grew up in San Antonio, not quite Brooklyn, where her dad served in the Air Force and her mom worked as a waitress and then at the post office. As she will tell you, her upbringing was steeped in the immigrant experience of many first-generation Americans. There was a constant struggle against racial, social, and language barriers as the Perez family found its place in America. In fact, when Myrna was a kid, her aunt would take her to the polls on Election Day. Even in her early years, she saw firsthand how cultural differences and Byzantine rules made it immensely difficult for Americans like her to engage in the political process, foreshadowing a career dedicated to the defense of voting rights and equal representation for all Americans. And make no mistake about it, and it was no mistake, rather, that she chose the legal profession as a means to achieve that noble goal. Myrna's family will tell you the story of how once, as a kid, she protested that her cousin tried to keep a fish he caught that was technically below the legal size for catch and keep. Remember what kind of fish it was?
It was probably a trout, right?
A trout. A trout. We have those in New York, too. It was the innate appreciation for the rule of law that propelled Myrna through Yale, Harvard, and eventually Columbia Law School, the first in her family to graduate from college. I hear these stories, and it gives me such faith in America, but such a strong desire to create greater and more equal justice in this country. We have so much potential. We are such a wonderful country. We just have to live up to it. And with a nomination like this, we are. After 2 clerkships on the federal bench, Myrna worked as a civil rights fellow in private practice before joining the Brennan Center for Justice at NYU, of course named after the great Justice Brennan. It was at the Brennan Center that Myrna established a reputation as one of the top voting rights and election lawyers in the entire country. For the last 15 years, she's been involved in election-related litigation. Everything from voter roll purges, discriminatory voter ID laws, the voting rights of formerly incarcerated people, and protecting the ballot from unlawful rejection. My colleagues, the federal bench has long been occupied by former prosecutors and corporate lawyers. While many of these people, many of whom I proudly recommended, have served admirably, it's past time that the federal bench reflect more accurately the true depth and breadth and talent that the legal profession has to offer. It's about time that civil rights attorneys, federal defenders, and voting rights experts like Myrna Perez join the ranks. Especially now, when our democracy in many ways is in peril, it's crucial that we elevate someone like Ms. Perez to the bench, someone we can trust to faithfully and equally apply the law to preserve our great democracy. But it's not only about her experience as a voting rights litigator. After all, she's going to hear all kinds of cases on the Second Circuit. What makes Ms. Perez so qualified for this job is not merely her experience, but her legal excellence. Just listen to what a few of her colleagues had to say about her. Brilliant, one fellow attorney wrote quite succinctly. A force of nature, another said. Another colleague rated her legal skills as simply, quote, off the charts. I would add one additional note to these well-deserved praises. Ms. Perez will serve as the first Latina to sit on the Second Circuit Court of Appeals since then Judge, now Justice, Sonia Sotomayor, whom I had the great honor of recommending to President Obama for a seat on the highest court. And let me just say, when I met Ms. Perez, she just knocked my socks off. Yes, she was brilliant, amazing. Yes, she had real compassion and depth of experience. And she had a scintillating personality that I'm sure will help her persuade fellow members of the Second Circuit to the righteousness of the causes that she will follow. So I can think of no one more fitting to carry on Justice Sotomayor's legacy on the Second Circuit than Myrna Perez. She's amazing. I'm so proud to nominate her. She carries my highest recommendation.
Thank you very much, Senator Schumer. We appreciate your remarks. And at this point, we're going to ask the staff to prepare for the questioning of nominees. The first panel will be Ms. Perez, who is seeking a spot on the circuit court, will be before the committee. And then the second panel will include the other nominees. So Senator Schumer is working this like a high school graduation. And he's attended many.
I've spoken at over 100 of them virtually this year. Graduations.
I'm sure virtuously too. Ms. Perez, why don't we ask you to please stand to be sworn? Please raise your right hand. Do you affirm the testimony you're about to give before the committee will be the truth, the whole truth, but the truth, nothing but the truth, so help you God? Thank you. Please proceed with your opening remarks.
Thank you, Chairman Durbin, Ranking Member Grassley, and members of the committee for considering my nomination today. Thank you, Senator Schumer and Senator Gillibrand, for your support, and Senator Schumer for your kind words of introduction. I also want to thank President Biden For this nomination, it is the honor of my professional life. I first want to thank my judges, the Honorable Anita Brody of the Eastern District of Pennsylvania and the Honorable Julio Fuentes of the Third Circuit. While they were appointed by presidents from different political parties, they had a shared commitment for the rule of law and impartial adjudication. I want to thank my friends and colleagues. It is not possible to enumerate the many ways in which you enrich me. The support you have shown me has meant more than you know. I want to thank my church family, St. Matthew's Evangelical Lutheran Church, my extended church family of Crossroads Prison Ministry, and Grace Van Voorst Episcopal Church for all of their prayers. They availeth much. In the hearing room is my cousin Hector Perez, standing in for my many wonderful cousins on the Perez and Garza side of my family. And of course, I want to thank my many aunts and uncles who played such a big part of my life during my formative years. To my cousins, my aunts and my uncles, my brother, my nieces and my nephews, thank you for the love from afar. My husband, Mark Munsell, is here. He is a devoted father and a really good sport about going along with my various community projects. Mark also gifted me with a bonus family who welcomed me with open arms. My parents, Myrna Perez and Victor Perez Jr., came in from Texas to be here today. They immigrated from Mexico to the United States as children, and while I never heard any complaints, I never heard the words discrimination or poverty, even as a young child, I knew that much of their life was very challenging and full of hardships. But to their credit, they never communicated anything but gratefulness for what they had. They taught me to be resilient. They taught me to be resourceful. They taught me to be independent. They taught me to be self-reliant. And they taught me to set high standards for myself and to work very hard to achieve them. But most importantly, they taught me that on my worst day, I am still better off than most of the world on their best. And finally in the room is my beloved son. He is my greatest source of strength, joy, and inspiration. Thank you so much, members, for giving me a moment to thank all the people who got me here today. I look forward to your questions.
Thank you very much, Ms. Perez. Let me, before we go into a few questions, say a few words about the disclosure yesterday of the article that was published in Sojourners magazine. Let me tell you that I have taken a look at the standards of the committee and believe that you are in total compliance both with the letter and spirit of the rules and law. You submitted to the committee an article which had been submitted for publication in May of this year before your nomination to the Second Circuit, and that article was published online yesterday. We have the letter of transmittal from you with the article in a timely fashion. Question 12A of the Senate Judiciary questionnaire requires nominees to provide all published materials, including materials published on the internet, to the committee. The question does not, however, require nominees to produce unpublished materials. So you complied completely as soon as it was published. I might also say that I read it. And having read it, some may take exception, I certainly believe they will. I would gladly give your article as a speech from me personally on the floor of the Senate any day of the week. I agree with what you said to the letter, and I would also say that it is factually correct in every aspect that I'm aware of. So we may disagree on policy. That's the nature of this United States Senate and our body politic. But in terms of the article itself, as I said, I believe that it's accurate, and I would embrace it. The only reference to the Republican Party was in the title, and that you said was not your choice, but the editor's choice. It speaks of issues in state legislatures without any partisan identification on that. But let's go further with this. You've worked with the Brennan Center, and Senator Grassley raised a point which is entirely valid. We raise this point all the time. Do you come to this really awesome responsibility with a bias? I think the world of Justice Brennan and what he did on the Supreme Court. As a matter of fact, I think there's a quote in here. Let me find it because it's worth remembering. There's a quote that said that Justice William Brennan was probably the most influential justice of the century. And the source of that quote was Anton Scalia. So Brennan himself was a well-respected man, and I have turned to the Brennan Center many times when there are questions of policy that they have looked into. What would you say of your own philosophy? textualist, originalist, I don't know all the terminology of the Constitution. Please, the floor is yours.
Certainly, Senator Durbin, thank you so much. I think the first place you start when examining the Constitution or a statute is with the text. It is the most probative example of how it should be interpreted. I think if on its face the text is not clear, you would then look to precedent, and if confirmed, I would be looking to precedent both from the Supreme Court and the Second Circuit. If that still doesn't answer the question, you look to canons of construction. You perhaps approach a legislative history, but there is more than 230 years of jurisprudence in this country, and there is relevant and probative jurisprudence on quite a number of issues. But you start with the text, sir.
Members of the Senate and many others swear allegiance to that Constitution, to defend it. People have given their lives in defense of that Constitution. And yet I would say, my own personal opinion, as great a document as it is, and it is great, it is not perfect. Its treatment of African Americans, women, and others reflected the mores and standards when the Constitution was written. So I would just say, and you don't have to comment, that I am not a literalist when it comes to characterizing African Americans as two-thirds of a citizen, and not including women in the right to vote. That, to me, is a reflection of the times, and thank goodness those times have changed. Speak to me, if you will, though, about the right to vote. That is the central issue that we're discussing in so many aspects. A group of Texas legislators decided to come to Washington so that they wouldn't make a quorum in Texas over controversy involving a voting rights law. People feel very intensely about it. Comment on that, if you would.
Senator, the right to vote keeps us free. It protects us from tyranny. It is preservative of all other rights. And as an advocate, I have been duty-bound to ensure that the promises this Constitution makes about being able to participate in your own self-governance is actualized. The position before you I seek is one of a different role, one in which I would not be involved in questions of policy, but merely evaluating the laws that were put before me alongside the record that the parties put in. But the fundamental core of what is great about our country, the Constitution and the promises that it makes that we all deserve a free, fair, and accessible vote, is something that is timeless and something that is bipartisan.
I know the answer to the question I'm about to give is very simply yes, but I'm going to ask you if you would expound on the notion. Have we had any difficulty in the history of this nation in providing the right to vote to all Americans?
Yes, sir. There are times where we have not lived up to the great ideals of the Constitution, and I'm very proud to say that we are improving on that, but it requires vigilance, and it requires all of us Americans being part of the we the people in order to make and continue to make our union more perfect.
Thank you. Senator Grassley.
Yeah. Thank you, and congratulations on your appointment. I want to talk generally about the approach of this administration. So many names, not just yours, but others that we've already dealt with, about these nominees refusing to even admit that they have a judicial philosophy, let alone talk about what their own judicial philosophy is. Even Judge Gelpi, who literally wrote a book on the Constitution, didn't seem to want to talk about it. But I think you're uniquely suited to answer these questions because you've spoken many times about the living Constitution concept in connection with your work at the Brennan Center. What does the living Constitution concept means to you? You obviously agree with the living Constitution as a method of constitutional interpretation.
Senator Justice Brennan made famous and popular the idea of a living Constitution. Obviously, I've never spoken to him about what it meant or what his interpretation meant. I do think as a nominee, I believe and am comfortable saying that the Constitution is an enduring document. Its great values of incredibly important things like equal justice under the law, liberty, the right to free exercise, all of those important attributes of the American experience are still relevant and guiding us today. And if they continue to guide us, we will continue to be the greatest country in the world.
Thank you for your willingness to express that. Others haven't been quite that outcoming. On May 27th, 2021, you spoke on a virtual panel titled Voting Rights in America, Ensuring Fair and Full Voting for All. During your introduction, you spoke about Justice Brennan and his judicial philosophy. You also went on to say, quote, "If you're one of these people who think that we were at our best when our country was first founded and didn't include women or people of color or people without property in the electoral process, this is probably not the conversation for you," end of quote. Who were you describing in that description?
Senator, I do speak a lot, so I'm not 100% confident that I remember the conversation. If it is the conversation I remember, I was getting a lot of hostile, inappropriate comments in the chat, and I was worried that it was distracting the audience and frustrating the organizers, and so I was trying to explain to the audience members that I was asked to speak on a particular topic and I intended to speak on that topic as opposed to engaging with nameless anonymous people via chat.
Okay, let me follow up. Is it your view that originalists think America was, quote, unquote, at its best when people of color couldn't vote?
Senator, I think labels that get thrown around a lot, like originalist or inchoate and constantly shifting, and so they're too broad and they're not particularly helpful in terms of answering questions. I will say that the people I have encountered that call themselves originalists, I do believe that our country that is inclusive is preferable than the restrictions we saw when the country was first founded.
Can you name any originalists who might hold that view?
I'm sorry.
Could you name any originalists who might hold that view?
Who hold what view? The idea that the country is improved when we can all include? We are all inclusive?
Okay, then let me go on to my last question. This deals with recusal. In your questionnaire, you said you would recuse yourself in matters which the Brennan Center was a party or represented a party. Does this also include matters which you or the Brennan Center advocated a policy position on? Let me follow up that question with, you have spoken about New York election laws and pending voting legislation in Congress, and your positions on those bills are quite clear. Can you comment today to recusing yourself from litigation involving that legislation?
Senator, I am very comfortable committing to consulting the statute of 28 U.S.C. 455 for recusals and talking to the administrative office and proceeding in accordance with those dictates.
Thank you very much.
Thank you so much.
Senator Whitehouse.
Thank you, Chairman. Welcome,
Good
Ms.
morning.
Perez. I am delighted that you are here and look forward to supporting your confirmation.
I'm going.
I want to ask you a question regarding the Voting Rights Act. There has been some criticism of your nomination that you have dwelt unduly on issues of race with respect to the Voting Rights Act. Could you let us know why, with respect to the voting rights law, that is actually a necessary thing to consider?
Thank you, Senator. For the past 15 years or so, I have been an advocate on behalf of an organization and on behalf of clients who seek a free, fair, and accessible vote. As a civil rights litigator, I am duty-bound to be hypersensitive and attuned to issues of disparity and racism, and to protect and guard against any threats to a free, fair, and accessible vote. And as such, I have been vigilant about monitoring and watching and researching potential threats to a fair vote.
And in fact, Section 2 of the Voting Rights Act makes it actionable to deny or abridge the right of any citizen of the United States to vote on account of race or color, does it not?
That is correct, sir.
So that's actually in
Part
the
of-
law,
Part of my job, sir.
part of your job. And it's part of your job because it's part of the law.
That is correct, sir.
Yeah. I'm actually, I think, more to your side than to the originalist side as regards the Constitution. I like your use of the word enduring. I think we do have an enduring Constitution, and we do have principles in it that endure, but that have to adapt to changing circumstances in society, whether it's new means of communication or new economic realities. And I think too often originalism is used as a device to try to impose value judgments rather than principle. I think it was William F. Buckley who years ago said the purpose of conservatism is to stand athwart history yelling, "Stop." And I don't think the Constitution is designed that way. So I just want to say I appreciate your perspective. I tend to share it, and I think your use of the word enduring is a very appropriate one. I don't know if you want to elaborate on that in any respect, but thank you for saying that.
I would say, Senator, that I love the Constitution. I love the principles it sets out. I love that under the Constitution, we are all equal under the law, that we all have a right to life, liberty, and the pursuit of happiness. I love that we all have the right to free exercise, and I am entirely persuaded in the wisdom of the frameworks it sets up, things like the rule of law, separation of powers, an independent judiciary, and federalism. As part of those frameworks, it allows us as Americans to live up to our ideals. So those frameworks improve our values, and those values guide our framework. And I think together, the country is getting stronger and can get stronger.
In the context of frameworks, let me ask a final question here that I ask of a great many of the nominees who come before us, because in the framework of the United States Constitution is the jury, criminal jury and the civil jury. And the importance of the jury was something that was really evident to the founders. It was part of the casus belli of the Revolution. It was mentioned in our founding documents. And I think many historians see it as a way for popular expression of governance by local communities. And so it's been with some degree of distress and dismay that I've watched jury trials more and more evaporate in the federal system. A lot of it has to do with Supreme Court decisions that have made it easier for big and powerful interests to get out of cases before they, in some cases, even have to properly answer discovery. In other cases, it's been allowing big, powerful interests to divert people away from juries and into mandatory arbitration, for instance, which is very often a rigged game. Would you say a word about the historic role of the jury and whether you have any hesitation about protecting and defending the institution of the jury as contemplated in the Constitution?
Senator, the jury is an important bedrock position in our judicial system. Certainly as an appellate court judge, I would not be interacting with juries, but I certainly would apply all of the standards of deference and reverence for the decisions issued by juries.
Thanks, Senator Whitehouse. Senator Tillis.
I'll defer to Senator Kennedy.
I'm sorry, Mr. Mr. Senator? No, you go ahead. Well, that's very
We
kind of
can
you.
ask you to do it jointly,
That gives us 10 minutes?
Yeah, really.
but you have to fight over the 10 minutes.
I'll try to not take my whole time here. Thank you, Mr. Chairman. Counselor, how are you? Good morning. Congratulations.
Thank you so
Do
much.
you think the Constitution should be used to create new rights?
Senator, I think the Constitution is an enduring document and that.
Yeah, I agree with you. It's been around a long time. It's enduring. And I'm fond of it. You love it. I'm fond of it too. But do you think it ought to be used to create new rights?
Senator, I think it is constantly being interpreted, and the Supreme Court has, through the 230 years of jurisprudence, has found rights in it.
Yeah.
And if I am confirmed as an appellate judge, I would faithfully apply Supreme Court precedent.
Yeah. But are you going to use it to try to create new rights?
Senator, appellate court judges don't create new rights. They take the
Sure they
record below
do.
them.
Sure they do, Counselor. We've both been at this a long time. They do it all the time. And then it goes up to the Supreme Court, and the Supreme Court says yay or nay, or sometimes they don't say anything. Let me ask you this. What barometer should we use to decide whether a federal judge ought to create a new right or the people's elected representatives through a Congress or a legislature? What's the standard you use there?
Senator, we have co-equal branches of government. The legislature does the policy making, the judiciary.
Yeah, but what's the standard? I'm sorry to interrupt you, but we had this problem in the last administration, and we have it in this administration. If you could just answer my question, because 5 minutes just goes like that. What standard do you use personally to decide whether a new right ought to be created by a federal judge or by the United States Congress if it's a federal right?
Senator, I would be applying precedent, and precedent
I
has standards of
stipulate that you're
review.
going to apply precedent. I stipulate that, so let's take that off the table. What standard should be used to determine whether a new right ought to be created by a court, a federal judge, unelected, appointed for life, or a United States Congress?
Senator, appellate courts have standards of review when looking toward lower court decisions, and I would apply
Come on,
that standard.
Counselor, you're not answering my question. It's a real simple question, and you're very smart, and you know what I'm asking. You believe in a living Constitution, okay? I get that. That's a legitimate point of view. You say you don't understand what an originalist is, but I don't think you're being candid there. But this is let me ask my question again. What standard should be used to decide if you're going to create a new right in the Constitution, whether that right ought to be created by a federal judge or the people's elected representatives? Very simple.
Senator, the federal courts are of limited jurisdiction. The appellate courts sit in between a Supreme Court.
Okay, you're not going to answer it. I get it. When you were at the Brennan Center, you're still there, right?
I'm on leave, sir.
Okay, well, but when you were there, did you advocate federal courts create new rights under the Constitution?
No, sir.
You never did?
No, sir.
Okay.
Right to vote is protected in the Constitution, and it's protected.
So you never asked for new rights, you just said they're already there?
Yes, sir.
Okay. How do you know a right's already there if it's not explicit?
In the case of voting?
No, just in general. If I read your resume and it's not, something's on there, well, that's a bad example. If you look at the Constitution and it doesn't, let's say reparations, okay? And it doesn't talk about reparations. How do you know whether a right should be granted if it's not there? That's what I understand you to be saying with the living Constitution.
Senator, again, a case would not come before an appellate court unless parties presented an argument.
I get that. I understand how a lawsuit's tried. Let me ask you again. How do you know if a right's not explicit in the U.S. Constitution that it's really there? It's hiding, it's lurking, and we just have never seen it.
Senator, in Marbury versus Madison, the Supreme Court said that the Supreme Court interprets the Constitution.
Right.
I would look to precedent. I would look to see.
What if there's no precedent?
There's always some precedent.
See, here's my problem, Counselor. This is where I think you're headed. I think what you want to do on the federal bench is advance a social agenda and rewrite the Constitution every other Thursday to advance a social agenda that you can't get by the voters through their elected representatives.
Senator.
Now, that's a legitimate thing to be for. This is America. You can believe what you want, but you spent your whole career doing that. And it bothers me that you're not defending that here, that you're dodging my questions.
Senator.
You're not the only nominee who's done that. It happened under the prior administration. It must be something in the water at the White House. But I'd respect you a lot more if you just up front said it.
Senator, I believe in the value of precedent. I think it makes our system.
So do I, but that's got nothing to do with our discussion. We both know that. And I understand that you've been advised to say precedent, precedent, precedent. When in doubt, is it raining outside? Precedent. But it inhibits our ability to have a rational discussion. Thank you, Mr. Chairman.
Do you want to complete your answer, Ms. Perez?
I'm fine, thank you.
Thank you. Senator Tillis? Oh, I'm sorry, Senator Coons.
Thank you, Chairman Durbin. Great to be with you, Ms. Perez. The committee received a number of glowing letters in support of your nomination. I was struck by one in particular, a letter that I reviewed closely from Reverend Canon Dr. Allison DeFore of the Episcopal Diocese of Florida. Before his service as a faith leader, Reverend DeFore practiced law, serving as a county judge, a circuit judge, a prosecutor, a sheriff of Monroe County, and a public defender. He also sought elected office as the Republican nominee for lieutenant governor. And he emphasized in his heartfelt letter of support for you, and I quote, "Myrna is, as a lawyer and individual, a person of the highest integrity. She's thoughtful and sound in her judgment and committed to principles of justice that transcend politics. She embodies the true meaning of public service and would be an exceptional federal judge." He adds, "This is an informed opinion." Something many of us in the Senate would benefit from adding on occasion if it were true. Given this informed opinion that I assume is rooted in your close work together, I'd just be interested in learning more about your work with the Reverend and former judge and sheriff on criminal justice issues. What motivated you to engage in that work, and what lessons have you taken from that work which you might apply in your future service?
Certainly, sir. The Brennan Center takes the position that all Americans who are living and working in the community should be able to have the right to vote. And I have been very fortunate to work with people from all kinds of backgrounds to try and work in the legislative branch primarily to make that so. Reverend Allison is one of the many different kinds of people that I have worked with on this issue. There are quite a number. And I think it is really encouraging that there are still some issues in which we can get bipartisan support for.
We've managed to get bipartisan support for criminal justice reform, even on this committee, with the leadership of our chairman. Ms. Perez, I was also struck that your work has included extensive litigation experience, both at the district and appellate level. And I'd like to give you a chance to talk about your litigation experience and its relevance to your service, should you be confirmed in the position for which you've been nominated. How would your experience with complex litigation inform your service as a judge, if confirmed?
It would give me a very strong appreciation for what it is that district courts have to do. It would make me be very faithful to the standards of review. It would remind me every day that the parties are the masters of their lawsuits. And it would also bring to me almost 2 decades of experience analyzing constitutional and statutory claims, voluminous documents, a massive amount of motions practice, and would allow me to make sure that I am aware of exactly what it is that parties are doing when they are arguing and prosecuting their cases.
That's great. Thank you very much. I appreciate your testimony before this committee today. No further questions. Thank you, Mr. Chairman.
Thanks, Senator Coons. Senator Tillis.
Thank you, Mr. Chairman. Ms. Perez, thank you for being here. Congratulations on the
Thank you,
honor
sir.
of being nominated, and to your family. And what's your son's name?
His name is Diego Isaías.
Welcome. I've got just a couple of quick questions. I was Speaker of the House down in North Carolina when we passed voter ID laws in the state, and I feel like it's difficult for me to understand. I think we have different views about this, but when we tried to do everything we could to make sure that anyone who needed an ID in order to vote, that we would even pay for it, that we would make sure that we gave people not only the opportunity to vote, but fully participate in civil society. When I went through TSA, I had to present an ID. When I checked into a hotel 2 weeks ago, I had to present an ID. When I got prepped for my surgery about 2 months ago for prostate cancer, I had to submit an ID to be admitted into the hospital. And it just seems to me that I'd like for us to get to a point to understand if we want every American to fully participate in every aspect of society, that an ID is a pretty important part of that. I'm not going to ask you, I know where you are on it, so we'll agree to disagree on that. But I did want to ask you about something I think you argued, and there was a ballot harvesting case in the 9th District down in North Carolina. And in that particular case, it was a Republican candidate, so I appreciate, again, your consistency on the issue. But give me an idea in a state like North Carolina where ballot harvesting is not allowed, why you think that is a voter suppression measure.
Certainly, Senator, I am happy to answer your question. I would, again, recognize that if I am confirmed, I would be taking on a different role, and you are referencing work that I did as an advocate. We examined the issue in North Carolina and found that there was a disadvantage that was occurring because of the illegal activity that happened there. And we responded.
For those whose ballots were harvested?
Those whose ballots were tampered with and thrown away. And as an advocate, I was duty-bound to call that attention to the public to ensure that I could do everything within my role, that those voting rights of the impacted voters would be vindicated.
Do you, just on a broader question, again, I understand the limits that you have because of matters that may come before you, but wouldn't it also follow then that the same rationale for saying that those votes had been suppressed because they had been tampered with opens up ballot harvesting to potential fraud?
Senator, the striking the balance between how much restrictions you need to ensure fraud doesn't happen is something that's better suited for the legislature. If I am confirmed, I would merely be evaluating the law and the precedent before me as applied to the facts and the record that the parties put before me.
Thank you, Mr. Chair, and congratulations again to the family and the story of your family. Thank you.
Thank you.
Senator Hawley.
Thank you, Mr. Chairman. Thank you, Ms. Perez, for being here. Congratulations on your nomination. I want to just pick back up where Senator Tillis left off when it comes to ballot harvesting. This is an issue that the United States Supreme Court has recently taken up in the Brnovich case. You've had quite a lot to say about the Brnovich case. You've had quite a lot to say in quite a number of the Supreme Court's precedents, which you would be called upon to apply. So I'd like to get your views on those. You seem to be fine and perfectly willing to characterize Supreme Court precedent, so I'd look forward to your testimony here under oath. You said that the Brnovich case was a clear-cut case. The Supreme Court ruled, and you actually characterized some of the arguments in the case made by Brnovich and made by various amici in support of Arizona as outrageous and harmful, including a brief filed by my colleague, Senator Cruz. So I take it you think the Brnovich case was wrongly decided?
Senator, my views on the Brnovich case are immaterial because if confirmed, I would be duty-bound to apply it, and I would do so without reservation.
Oh, I think they're quite material to get at your judicial philosophy. So let's try again. Do you think the Brnovich case was wrongly decided? You said that the case was clear-cut. The Supreme Court ruled differently than you thought. So I take it you think it was wrongly decided.
Senator, I would apply the precedent without reservation.
Do you think the Brnovich case was rightly decided?
Senator, I would apply the Brnovich case without reservation. It is the law of the land. The country that I care so much about depends upon stare decisis and the application of precedent.
Well, that's not what I'm asking you. I'm asking you about your comments on a Supreme Court case, which you will indeed be duty-bound to apply, but I think understanding your view on that case is relevant. Let's try a different one. Shelby County. You said that the Shelby County case gutted voting rights. So you think that case was wrongly decided. Will you be able to apply that case faithfully?
Without reservation.
Do you think that the Heller case was wrongly decided?
Senator, Heller is the law of the land, as is its application through the states of McDonnell. I would apply it without reservation.
Do you think Brown versus Board was wrongly decided?
Senator, I would apply Brown versus Board without reservation.
Do you think Brown versus Board was rightly decided?
Senator, I think it was rightfully decided. And
it was rightly decided. Shelby County was wrongly decided, you say, but you won't say about the Brnovich case, you won't say about Heller. What's the line here? How am I to judge how you're going to apply the law if you won't be frank with the committee about what you've said in the past and about your own views now? I mean, you've been an activist for quite some time. You've commented on many laws. You've called voter ID laws like we have in my state of Missouri, which, by the way, the voters of my state passed directly. The voters passed. You've criticized those as Jim Crow type laws. That's an extraordinary statement for a judge, someone who wants to be a federal judge, not an activist, not a constitutional lawyer, a federal judge. You've called the precedents of the United States Supreme Court, you've talked about them as gutting voting rights. You've criticized them in the harshest of terms. You've done this repeatedly. So I think it's fair game to ask about your view of precedent. So how are we going to know? I mean, let's come back to the Heller case, the McDonald case that followed on from Heller. Was that rightly decided?
Senator, I would apply it without reservation. And if I may say, I, for the last 15 years, have been an advocate when under our system requires zealously pursuing the interests of my clients. A judge plays a completely different role. And by accepting this nomination, I am pledging to this body, to the American public, before my God, that I would faithfully discharge my duties under the Constitution, which require me to put aside any personal policy viewpoints I have and examine what the matter is before me and apply the precedent of the Supreme Court and the Second Circuit. And I do this without reservation. I am willing and able to serve my country in this way.
Do you still think the Shelby County case gutted voting rights?
Senator, as an academic, as a researcher, as an advocate, I have done a number of research where I have been able to lift out and identify instances in which policies that passed that were not likely to have passed had it not been for Shelby County. But Shelby County is the law of the land, and I would apply it without reservation.
Let's talk just a little bit about your broader judicial philosophy. You've been an advocate of living constitutionalism. You said in 2021 that if you are one of those people who think that we were at our best when our country was first founded and didn't include women or people of color or people without property in the electoral process, then this conversation about living constitutionalism is probably not for you. I take that to be a disparagement of originalism. You've also said that the Constitution is not static or frozen in time, but it has to evolve and be dynamic in order to actualize its principles. So is this the judicial philosophy you would follow in cases of first impression? When you don't have a controlling precedent point, you have to construe the Constitution. You would look to dynamic and evolving principles?
Senator, I believe in the conversation that you are speaking of, I was talking about Justice Brennan's definition of a living constitution.
What would be yours?
I believe that we have a constitution that is enduring. I think its great values are applicable and relevant and can guide us today. I think they're timeless, and I believe that they make our country strong.
Do you consider yourself a living constitutionalist?
I don't think those kinds of statements are helpful in explaining the approach that I would take, which would be first examining the text, then examining the precedent. And if I needed to go beyond that, I would be looking at the canons of construction, the legislative history, the structure of what was at issue. And more importantly, I would be bound by the record of the parties that presented the case to me.
Well, my time has expired, so thank you, Mr. Chairman, for your indulgence on this. I'll just say, that Ms. Perez, in conclusion, I want to echo Senator Kennedy's remarks that I think given your very lengthy record of statements about Supreme Court precedent, about many court precedents, I think to come to this committee and to refuse to answer questions about those, to refuse to explain your statements, to say you're not going to comment about decisions. You have commented frequently about decisions. I just think that, with all due respect, that's not candid. I think it's frankly not transparent with this committee, and I won't be able to support your nomination. Thank you, Mr. Chairman.
And I might add to my friend from Missouri and others, it is not unprecedented. Trump nominees came before this committee for 4 straight years, and with the exception of Brown versus the Board of Education, which they acknowledged starting in around 2019, they refused to say to a person whether other cases were, particularly recent cases, correctly decided. It is a question often asked by the other party in this committee, and the answers you've given are ones we've heard before. And I don't think it should come as a surprise to my colleagues. Senator Padilla.
Thank you, Mr. Chairman, and appreciate the context and background. Ms. Bettis, how are you?
Great to see you, sir.
Great to see you. You have spent virtually your entire career advocating for greater access to the ballot and stronger protections for our fundamental right to vote. In the course of that work, clearly you've litigated cases in court, you've advocated for policy changes in states around the country, as well as right here in Congress. And you and I have worked together in my prior capacity as the chief elections officers for the state of California. So I know how important advocacy on behalf of the right to vote is. Simply put, we are a stronger democracy when every eligible citizen is able to vote, particularly free of harassment, intimidation, and without any unnecessary obstacles or barriers. Have a sort of a bigger picture question in why voting rights? Why have you decided to dedicate your career to defense of our right to vote, number one? And I think more specifically, and for purposes of this committee, how your views on policy, which we're entitled to have, but how would they affect your rulings as a judge?
Thank you, Senator. I think the right to vote keeps us free. I think it protects us from tyranny. I think it is preservative of all other rights. And as an advocate, I have been privileged to work alongside with all sorts of Americans from all sorts of backgrounds to make sure that our ability to govern ourselves is able to happen because we all have a free, fair, and accessible vote. With respect to policy, that is a role that is an active part of my docket, but by accepting this nomination, I am pledging to no longer participate in policy disputes, and instead, I will impartially and objectively review the law, apply it to the record before me, and be faithful to the precedent both of the Supreme Court and the Second Circuit.
Great. I appreciate that answer, and I thank you for your clarity. I thank you for your commitment, and I thank you for your willingness to serve in this capacity should you be confirmed. I do have another question, and sadly, very timely. At the end of the last election cycle, we saw the rule of law tested when President Trump and his enablers filed over 60 post-election lawsuits, not even counting those that came prior to the election, 60 post-election lawsuits challenging the outcome of the election. Thankfully, court after court rejected President Trump's frivolous challenges. But there's no question that the system was strained by the former president's unfounded assault. As a voting rights lawyer, you saw this abuse of our judiciary up close. Can you speak to the importance of the rule of law and how you believe that judges can help exemplify and uplift it?
Thank you, Senator. The rule of law is a foundational principle. It is all over the way that our country works, in addition to things like an independent judiciary and separation of powers. I think it's one of the genius of our Constitution, and part of the reason why I am very comfortable that I will be able to set aside my past role as an advocate and accept the role of a judge if I am lucky enough to be confirmed is because our system requires an independent judiciary. I know that when I'm a litigant in court, I want to be able to go before a judge that allows me to make the arguments, allows me to make the case, and sets aside whatever personal viewpoints. Our system does not work unless judges do that. I am ready to do that. The country that I love so much depends upon it.
Thank you. Thank you for responses, and thank you, Mr. Chair.
Thanks, Senator Padilla. Senator Lee?
Thank you, Mr. Chairman. I'd like to follow up on one of the questions that Senator Hawley raised with you. Now, you said that you were referring in those discussions about a living Constitution to Justice Brennan's interpretive style. Is that correct?
That is what I believe the quote he was referring to was referring to.
And is this the quote in which you said while you were discussing, I think this was in a panel discussion just a couple of months ago that Senator Hawley was asking about, in which you said, if you're one of those people who think that we were at our best when our country was first founded and didn't include women or people of color or people without property in the electoral process, this is probably not the conversation for you. So I'd like to know first, what conversation is that? I want to understand the context here. What do you mean? What conversation isn't for you? Are you characterizing people who believe in originalism as believing that we were at our best as a country when we didn't include women or people of color?
Senator Lee, as I indicated to Senator Grassley, I do speak a lot, but if I remember that conversation correctly, I was getting a lot of hostile and inappropriate comments in the chat, and it was causing a disruption to the organizers and the planners who seemed to think that I would be engaging in some conversation with them. And so I was trying to set expectations for what the conversation would be like.
I understand that. It's good to know, but I'd still like to know what you were referring to.
I was trying, if again that was the conversation that I recall, and I believe that it was me attempting to de-escalate some people who believed that that conversation was a source of or was a potential for a back and forth over chat, which I was not going to let it devolve into.
Okay. Do you believe that's a fair characterization of originalists?
I do not believe that that is a fair characterization of originalist, and I, again, if this is the right conversation that I'm recalling, was trying to de-escalate folks who were disrupting a conversation via chat.
Now, in response to Senator Hawley's questions a moment ago, you said you were referring to the living Constitution, you were referring to Justice Brennan's approach to interpreting the Constitution, and then you said that that would not necessarily be your approach. Did I understand your response to his question correctly?
Senator, I am not a judge. I don't have a judicial philosophy yet, but my approach would be to first look at the text, then look at precedent, look at the canons of construction, and keep myself limited to what the parties in the matter presented before me.
Okay. Insofar as you were characterizing Justice Brennan's approach to constitutional interpretation, how would you characterize that approach today? What is his approach? What was his approach?
Again, I've never spoken to Justice Brennan. I didn't have the pleasure of meeting him.
But you said a moment ago you were trying to characterize his approach.
He has had quotes about the Constitution not being static, as has Justice John Marshall in McCulloch versus Maryland. What I believe is true, and I believe it's a truism, is that our Constitution is enduring, that it has great values that are universal and timeless, and that those values make our country stronger. Values like freedom of religion, values like liberty, values like equal justice under the law.
Okay. So if you were confirmed, are you saying you would not adopt a living constitutional approach?
Senator, if I'm confirmed, the first place I would look when evaluating a constitution or a statute would be at its text. That is the most probative offering of what a piece of writing means. If required, I would look to precedent from both the Supreme Court and the Second Circuit. If that still didn't answer the question, I would look to the canons of construction, the structure.
I understand. Back in 2014, you described new voter integrity laws, including, as I understand it, voter ID laws, as representing, quote, the biggest voting rights rollback since the Jim Crow era. Now, personally, I think it's an insult to the brave Americans who engaged in the civil rights movement to draw any comparison between the heinous race-motivated requirements imposed by the Democratic Party under the Ku Klux Klan's influence, to compare those to today's common sense, race-neutral, and often bipartisan election security measures, which according to some polls are supported by a majority of African-American voters. Do you stand by that statement today that voter ID laws are the biggest voting rights rollback since the Jim Crow era?
Senator, I understand and very much believe in the importance of election integrity. Elections are how we resolve our political differences peacefully. The Supreme Court has spoken and provided standards for assessing voter ID in the Crawford case. If I am lucky enough to be confirmed, I would be duty-bound to apply that precedent to any case in controversy that came before me, and I would do so without hesitation or reservation.
I understand that, but I am asking about a statement that you in fact made. Do you stand by your statement that it's the biggest voting rights rollback since the Jim Crow era?
Senator, if that is the statement that I recall, it was occurring alongside a great number of pieces of legislation across the country that, as an empirical matter, looked different than what we had seen since earlier times, and that was what the reference was to.
So you were not referring to voter ID laws?
Again, if I remember correctly, it was a wide array of laws that would have included voter ID laws, because around the time period that you're talking about, we saw a number of them introduced. But again, the Supreme Court has said that within certain confines, the voter ID laws are acceptable. The Fifth Circuit en banc also said that there are times when voter ID laws cross the line. If I am a judge, I would be required to look at all of the relevant precedent and examine any law that was before me to figure out if unlawful discrimination was present.
I see my time's expired. I do find it concerning that the witness still hasn't distanced herself. I understand sometimes people say things and later regret them, but she still hasn't distanced herself from statements made to that effect a few years ago, and I think that's significant. Thank you.
Thank you, Senator Lee. Senator Cruz.
Thank you, Mr. Chairman. Ms. Perez, as I look at your career, I see the career of someone who has been an activist, and I believe a radical activist. You have waged litigation campaigns and opposed voter ID laws. You have opposed voter integrity laws. You have opposed prohibitions on ballot harvesting. You have advocated for felons being able to vote. As I look at your record year after year after year of being an extreme partisan advocate, I'm left with the very likely conclusion that if you were confirmed to the bench, you would likewise be a radical activist on the bench. Voter ID laws, as Senator Lee just pointed out, you described as the greatest rollback of voting rights in this country. 80% of Americans support voter ID laws. 60% of African Americans support voter ID laws. Do you believe voter ID laws are constitutional?
Senator Cruz, the Supreme Court has said that there are no per se restrictions against voter ID laws in Crawford.
I asked what you believe. I was one of the parties litigating in Crawford, so I'm very well familiar with that case and led a coalition of states defending voter ID laws, and Justice Stevens wrote the majority opinion upholding Indiana's voter ID law. My question to you is, do you believe voter ID laws are constitutional?
Senator, I believe they are constitutional. I believe that they can be constitutional because the Supreme Court has said they can be constitutional, and in Marbury versus Madison, the Supreme Court gets to decide. That is what our system depends on. We have a concept of vertical stare decisis. We have rules of law. We have
Ms.
precedent.
Perez, just a couple of months ago, in March of 2021, you said that the voter ID laws that had been passed were due to, I'm going to quote you to get your words right, anxiety over the browning of America, and people having anxiety of the fact that certain folks in power are not going to be able to stay in power. Do you believe the 80% of Americans who support voter ID laws and the 60% of African Americans who support voter ID laws are doing so because they're concerned about the browning of America?
Senator, that quote is clearly referring to politicians. It's not referring
All
to
right,
African
which
Americans.
politicians here do you believe are concerned about the browning of America?
Senator, that context was with respect to state politicians.
So it's only state politicians?
Senator, that context that I'm on record for, we're referring to state politicians.
All right, well, let's talk about politicians here in this body. As you know, I filed an amicus brief on behalf of 11 senators in the Brnovich case. You made a comment that the brief that I filed was outrageous and harmful. Do you stand by that characterization?
Senator, the Supreme Court, as you know, issued its decision in the Brnovich case and struck down, and upheld the restrictions on Arizona.
Okay, I'd like you to answer my question. Do you stand by the characterization that the amicus brief that I filed on behalf of 11 senators was, quote, outrageous and harmful? That's how you characterized it.
Senator, the Supreme Court has issued its ruling on
I'm going to
Brnovich.
try again. Do you stand by your characterization? I'm not asking you what the Supreme Court did. You described an amicus brief filed on behalf of 11 senators as outrageous and harmful. Do you stand by what you said just a few months ago?
Senator, what I said as an advocate when it was pending before the court is not relevant to the issue
Do you
before
stand by it or do you retract it? You have a choice.
Senator, as an advocate, I pursue...
Okay, you're going to refuse to answer me on that. I assume you also believe the Supreme Court's 6-3 decision agreeing with the position advocated in my amicus brief. I assume you believe that decision was also outrageous and harmful because that's the language you used.
Senator, the Brnovich case is the law of the land. It has been
So
settled.
you're not going to answer that either.
The law of the land has been settled. What I am going to say, Senator, is that I am pledging to apply precedent.
So at the time you discussed the brief filed by a number of senators on this committee as outrageous and harmful. At that time, had you had any discussions with the Biden administration about being nominated to be a judge?
I would need to remember the timing a little bit.
When was the first discussion you had with the Biden administration about being nominated to be a judge?
I would need to reference my Senate Judiciary questionnaire because that's where I recorded it. I don't have it committed to memory.
So you have advocated that felons should be able to vote. Do you believe all felons should vote?
Senator, my work and advocacy has been on behalf of persons who are living and working in the community.
Do you believe currently incarcerated prisoners in jail should be allowed to vote?
Senator, I have been advocating on behalf of people who
You're not answering my question. I didn't ask what you've advocated in the past. I'm asking what you believe.
Senator, the canons of judicial ethics preclude me from answering that question because a situation may come before me.
So let me ask you this. You have advocated in favor of a living constitution, and indeed, as both Senator Hawley and Senator Lee asked you about, you have disparaged those who believe in originalism as essentially racist and bigots. How do you think you will be able to serve with colleagues on the Court of Appeals if you have disparaged their constitutional interpretation as racist and bigoted? And secondly, why is it that when you advocate a, quote, living constitution, that somehow the livingness of it always makes the Constitution agree with the policy positions you happen to embrace. How is that consistent with democracy, to have a judge able to implement whatever policy positions you believe in?
Senator, we have had more than 24 amendments added to the Constitution since it was ratified in 1788.
But that's not what a living Constitution is.
Women-
A living Constitution means you as a judge, if you're a judge, can change it to whatever you want, and that the voters don't get to speak on it. Isn't that right?
Senator, women now have the right to vote.
We passed an
African
amendment for
Americans-
that. That's a terrific victory, and it was done the right way through an amendment. A living Constitution is judges changing it. Why is judges changing the Constitution to meet their policy preferences, consistent with any respect for the democratic process and the ability of voters to decide policy issues?
Senator, it is clear that our great Constitution is one that is enduring. It is clear with things like Brown versus Board overruling Plessy versus Ferguson that evolution happens. It is also clear that our great Constitution establishes separation of powers. There are bodies like this one that engage in policymaking. There are judges that review the cases and controversies that are put before them. I am pledging, by accepting this nomination, that I am going to cease being an advocate, and I would impartially, without reservation, objectively apply the law to the facts of the case and controversy before me.
Well, your record is overwhelmingly to the contrary.
Thanks, Senator Cruz. Senator Blumenthal.
Thanks, Mr. Chairman. The simple fact of the matter is you've never been a judge before, have you?
That is correct, sir.
So when my colleague, Senator Cruz, says your record is overwhelming to the contrary, I'm not sure what he is referring to. You have been an advocate, correct?
That is correct, sir.
And tell me how you view the role of advocate as being different from a jurist.
Thank you. In the great genius of our Constitution, people play different roles. Advocates zealously argue on behalf of their clients in as many fora as they can. I have had the privilege and pleasure of doing that. Judges take on a different role. They are limited in what they have jurisdiction over. They are limited in the cases that come before them, and they are limited to the arguments, what parties put before them, and they are limited to binding precedent. I believe that the most important thing a judge can do and must do, is in fact duty-bound to do, is to impartially and objectively apply existing precedent to the facts and the record of the case before them.
As an advocate, you've had strong beliefs and you have strong values, and you've advocated causes strongly. I take it as a member of the Court of Appeals for the Second Circuit, you would be able to put those beliefs and values and positions aside and look at the law, specifically the Constitution and the statutes of the United States of America, correct?
Not only would I be capable, sir, I must. The country that I care so deeply about depends upon people playing their roles. And I, if given the chance to serve this country, would not betray its values of an independent judiciary. I would faithfully, to the best of my ability, uphold my duty under the Constitution, which would be to fairly and impartially evaluate the cases and controversies before me.
And in fact, all of us who have been advocates, and I've argued cases in the Court of Appeals that I expect you'll soon join, as well as the District Court and the United States Supreme Court, as well as state courts in Connecticut, like you. As an advocate, you don't want to be an objective, neutral arbiter. You want to be on the side of your client and your cause. That's your record. And if you were, in fact, acting as a judicial official while being an advocate, you'd be betraying your client and your cause, wouldn't you?
That is correct, sir.
So when Senator Cruz tries to argue you shouldn't be a judge because you were a good advocate, in effect, and I think he understands the point I'm making. Your record, in fact, exemplifies your faithfulness to the role that you have been playing as an advocate, because our whole system is designed to have fierce and ferocious advocacy on the basis of the law and the facts. In fact, sometimes arguing that courts should expand the law by an expansive interpretation. But whatever you have argued as a lawyer and an advocate, you accept the fact, in fact, I sense you embrace it, that you would have a different role as a member of the United States Court of Appeals for the Second Circuit.
That is correct, sir.
Thank you.
Thank you, sir.
Thanks, Mr. Chairman.
Thanks, Senator Blumenthal. Senator Blackburn.
Thank you, Mr. Chairman. Welcome.
Good morning,
And
Senator.
Congratulations.
Thank you.
To you. I just want to be sure I'm understanding some of the comments
Yes, ma'am.
that you have made. And basically, you're saying as you move to the role of a judge, you would set aside all of your previous opinions.
They would not make its way into any courtroom that I was sitting in.
So basically, you're saying you would erase all of this activism from your past.
What I'm saying, Senator, is that I would apply the precedent of the Supreme Court.
So
the
you're
Second
going to
Circuit.
say, what you're going to do is basically, when it comes to your philosophy of the law and your philosophy of the governmental structure, you are going to hit the reset button, and you will be a neutral and blank slate. Is that what you're telling us?
I will be an impartial and objective adjudicator limited to the subject matter and personal jurisdiction of the case before me and the arguments
Okay,
that the parties have put in
let's do
front of
this
me.
then. Let's go on to the issue of voter ID, because this is something that causes not only me, but a lot of people in Tennessee who are viewing your nomination. They're really unhappy about your nomination, because most Americans, as you've heard from others today, they support voter ID laws. They also support the fact that it is up to the state to tend to this. And they're very concerned about where you would go. And you know what? They really don't want activist judges. What they want is someone who is going to be an originalist, who is going to look at the text of the Constitution and look at precedent, things you've said you're going to do, but the answers to your question do not indicate that that is going to be what you're going to take. I get this funny feeling that you're trying to hedge us, that you've rehearsed your answers, that you're spouting out what you think will not get you into trouble, so that you can go through the confirmation process and then do the happy dance and get on the court and then go back to your activist ways. That is what is coming across, ma'am. That is what I'm perceiving. So talk to me just a little bit about what your view is of the Elections Clause. And then, do you agree that the states have the right to conduct the elections in their state in the manner that they see fit?
Senator, states play the primary role in election administration.
It is their prerogative, correct?
We have a system of federalism within certain bounds pursuant to the Election Clause and the statutes that this body has created. States play the primary role in the administration of elections.
So your previous work in election law and voter ID would not preference any of the decisions that you're going to make?
I would very strictly adhere to the precedent of the Supreme Court.
But you cannot
and
give me
Second
a
Circuit.
yes or no to that.
Yes. I guess if you don't mind rephrasing the question, I'd like to if I can.
I said your prior work in election law that will not influence your decision-making in election law. election cases.
If what you're asking, Senator, is whether prior policy positions as an
Your
advocate that I've
prior
taken.
work, that's right.
I am pledging to you that if I am confirmed, that I will set aside any personal views I have as to the merits of policy and apply the country's precedent, which includes cases like Crawford, which, as we have indicated before, says that voter ID laws are not per se unconstitutional, and I would apply Crawford and any other relevant Supreme Court or Second Circuit precedent on any matter involving a photo ID law that came before me.
Okay. I'm going to send to you a question for an answer in writing because I will not have enough time for you to give a fulsome answer. But it deals with felon enfranchisement on voting and the positions that you have taken in that previously. And you did not answer Senator Cruz's question about felons having the right to vote. And you were opposite of Governor DeSantis in having them pay all of their fines. So I will send that question to you in write for a written answer. And then I'm also going to send to you a question dealing with your qualifications. Mr. Chairman, thank you. I yield back.
Thank you, Senator Blackburn. Senator Cotton.
Thank you, Mr. Chairman. Ms. Perez, I watched some of the hearing on television earlier. I apologize. I missed Senator Hawley's question because I was on the floor voting. I just want to return to some of the things he said. My crack staff gave me a summary, but I assume it must be incorrect. Was it your testimony that Brown v. Board was correctly decided?
Yes.
Was it your testimony that you cannot say whether Shelby County and Brnovich are correctly decided?
Senator, there's an important distinction that if you will give me a moment of your time, I'd be happy to explain, but that is accurate.
So was Roe v. Wade correctly decided?
Senator, it is the law of the land and I would apply it.
Was Lochner correctly decided?
Senator, it is not really the law of the land anymore, but if I had been confirmed during that period, I would have applied it.
Was Dred Scott correctly decided?
Senator, it is.
Surely you can say Dred Scott was incorrectly decided.
Senator, it was incorrectly decided.
So what's the distinguishing line of cases you will say is correctly decided and cases you won't say? Because it seems like you're willing to say that they're correctly decided if you like them, but if you don't like them, you can't comment on it.
Senator, I do appreciate the question, and I think it is important, and I want to clarify this. As a judicial nominee, I am bound by the Code of Ethics to ensure that any prospective litigant before me knows that they are getting an impartial and fair hearing where they will not be prejudged, where they will be given the opportunity to present their case. I think that it will not happen that a case of the permissibility of de jure segregation in schools would make its way before me. And as such, I am comfortable that I would not be violating my code of ethics by commenting on it. There are a handful of other cases that may be true. Loving is probably one of them, Marbury versus Madison. Everything else, I would be very, very reluctant to give a potential litigant the wrong impression that they will not get a fair day in court.
What about abortion? That's a live issue in the courts.
And I am not.
You're not going to say whether Roe v. Wade was correctly decided.
That is correct.
Okay. Well, you certainly had a lot of harsh things to say in the past about cases like Shelby and Brnovich and some of the issues that were adjudicated there. In fact, we just got notice last night about this article that just was published that you wrote. The title of it is The GOP Campaign to Make Elections Less Free. You noted in the letter you sent with the article that you did not see or approve of the title before it was published.
That is correct,
Which
sir.
I can understand. Authors don't choose their own titles. I understand that. You didn't say whether you agree with it. Do you believe the GOP is campaigning to make elections less free?
Senator, the entire piece does not mention any political party, and that is because I am an advocate for the right to vote, and I would criticize any politician who would impede that right, irrespective of their political party.
Do you think requiring photo ID is an impediment to vote? shouldn't be permitted?
Senator, the Supreme Court in Crawford said that voter ID laws were not per se unconstitutional. However, if this circuit en banc said that a particular voter ID law was illegal. This is a case-by-case inquiry where we are fortunate enough to have precedent that I would apply faithfully and without reservation.
I know that, I think Senator Durbin said this article sounded like a speech he would give on the Senate floor. I agree. I don't think it proves the point you may have been trying to prove, though, Senator Durbin. Ms. Perez, you live in the New York City area?
I live in Jersey City.
Okay. How'd you get down here?
I took the Amtrak.
Okay. Did you have to show an ID to get your ticket or get on the Amtrak?
I don't believe so, sir.
Okay. Last time you flew, did you have to show an ID?
I did, sir.
Do you think that's an unfair restriction on your ability to travel?
That is the policy, and I am a rule follower, and I'm happy to abide by it because I can.
Okay. If someone commits a murder, do you think it's fair to call them a murderer?
If someone has been convicted
Oh, yeah,
for
convicted,
murder
yes.
under, yes.
If they commit rape, do you think it's fair to call them a rapist?
Have they been convicted?
Yes, convicted.
Yes, yes.
So if they commit a felon, do you think it's fair to call them a felon?
I think that that is a bit different because there's a temporal issue, and I think that there's a raging policy debate on that.
Because in the past, you've said that you don't like to use that word. But you said, I don't use words like felons to describe people. I mean, we don't describe people by a mistake that they made.
I don't. I believe that every person is a child of God capable of being redeemed, and I never look at anybody and see the worst thing that they've ever done.
If those convicted murderers or rapists get released from prison, often under misguided policies, do you think it's still fair to call them a murderer or a rapist?
Irrespective of what their label was, sir, I would be on record as an advocate of trying to advocate for their right to vote if the criminal justice system had deemed them to be fit to be living amongst us.
All right, thanks for your testimony.
Well, thank you very much, Ms. Perez, for appearing before the committee. You may receive some written questions, which we hope we will provide timely answers to.
I will do so, sir. Thank you.
Thank you very much. I'd like to let the staff prepare for the second panel and ask them to please step forward. I'm going to ask Senator Coons to take over while I go vote and return. So,
In terms of introductions and swearing in.
first thing off the bat, swear them in.
Yep.
They give their opening statements.
Yep,
Start
you'll
the
be back.
questions. I'll try to. See if I got everything.
Do you swear that the testimony you're about to give is the truth, the whole truth? Okay. And I don't need to. Please be seated if you would. I look forward to hearing from our, I'm sorry. We're all just going to have to stand back up to take the oath, so please don't be seated. I look forward to hearing from our next 5 nominees. Before making your opening statements, would the nominees please stand to be sworn in? Do you affirm that the testimony you are about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. And Ms. Cobb, you may begin with your opening statement.
Thank you so much, Senator Coons, to all the senators here, to Chairman Durbin for that wonderful introduction, to Ranking Member Grassley. I'd also like to thank Representative Norton. Thanks. That's much better. I'd also like to thank Representative Norton for recommending me and for President Biden for nominating me. I have been drawn to a career in the law for as long as I can remember. My father's an attorney. I have such a great respect for the role of our courts in our democracy to interpret the laws. And I do want to take some time to introduce family members who I have here today. First, my parents, James and Anita Cobb, who drove up from Michigan to be here with me to support me as they always do. Now that I'm a parent, I understand the significant sacrifices that they made to ensure that me and my sister had an education and opportunity. I would not be here but for their support. My sister, Jenna Cobb, is also here, who has been a best friend and an enduring source of support and encouragement. She is here with my brother-in-law, Keith Ferrugia, who's just been a wonderful addition to our family. I want to thank all of my friends, colleagues, for their support. And then last but not least, my son, Ricky, is here. He is missing slip and slide day at camp to support me here today. Everything that I do is to be an example for him. I'm so thankful that he has an opportunity to have a first row seat to see how our great democracy works. I look forward to answering the questions today. Thank you.
Thank you so much, Ms. Cobb, and my thanks to your family and to Ricky in particular. This will be a riveting and hopefully painless session during which your mother will answer some important questions. Your Honor, Ms. Merriam, if you would please proceed with your opening statement.
Thank you, Senator Coons, and thank you to the committee for holding this hearing and, frankly, all of these hearings. I do want to thank President Biden for the great honor of this nomination, and I want to thank both Senators Blumenthal and Murphy for their support in this process and for their very kind introductions. 4 of my favorite people are here with us today. My mother, Ann, my stepfather, Michael, my best friend, Paul, and one of my closest friends for over 30 years now, Jenny. My father, Dwight, my little brothers, Jonathan and Alexander, who are not so little anymore, and my baby sister, Lucy, could not be here in person, but I'm confident they're with us through the miracle of streaming video. There are many others I want to acknowledge who've supported me both throughout this process and throughout my career. My extended family, scores of aunts and uncles and cousins all over the country, from Alaska to Oregon to Colorado to Virginia to Massachusetts and just about everywhere in between. And I'm thinking especially of my Uncle Russ down in Florida today. I am blessed with an incredible court family in the District of Connecticut, which we believe to be the oldest operating federal court in the country. My phenomenal career clerk, Samantha, my term clerk, Annie, and my courtroom deputy, Andrew, make everything work. And I especially want to acknowledge my fellow magistrate judges who serve our court and our country with such skill and dedication. And finally, my friends from every stage of my life, from New Haven, from New South, from the district, from Edgewood School to law school, who have become like family to me, so much so that their kids call me auntie, and I love them like my own. So I appreciate the opportunity to speak to you today.
Thank you, Your Honor. Judge Pan.
Thank you, Senator Coons. I want to thank Chairman Durbin and Ranking Member Grassley for the opportunity to appear at this hearing today. I want to thank President Biden for the tremendous honor of this nomination and Congresswoman Eleanor Holmes Norton for recommending me to the President. I also want to thank Chairman Durbin for his kind introduction today. I am the daughter of immigrants from China. My parents, Wu Qing and Felicia, came to the United States in 1961 to pursue graduate degrees in New York City. They chose to remain here because they recognized that this country offered the best opportunities for their children, my sister Gloria and me. Both of my parents became American citizens. At their naturalization ceremonies, each of them took an oath of allegiance before a United States district judge. When they took those oaths, they never imagined that one of their children might one day be nominated to assume a position of such trust and responsibility. I think it's fair to say that my presence before this committee is a fulfillment of the hopes and dreams that my parents held when they chose to make their lives here in the United States. My parents can't be here today, but they're watching these proceedings from their home in Virginia with my sister Gloria. I want to thank them for the sacrifices and the choices that they made, which allowed me to become the person that I am today. With me in the hearing room are my wonderful husband, Max Steyer, our son, Zachary, who's 16, and probably will be asking all of the members of the committee for their autographs after this hearing. Also, I'm pleased to have with me my brother-in-law, John Neufer. My younger son, Noah, who is 15, can't be here today because he's in Sewanee, Tennessee at the Sewanee Summer Music Festival. I also want to acknowledge and thank other family members who are supporting me from afar. My cousins, Pearl Wong, Santos Shi, Stephanie Shi, and Debbie Wen are watching from the great state of New Jersey, which is where I grew up. And my in-laws, Serena Steyer and Stephen Burton, are watching from the great state of Iowa. Thank you, and I look forward to answering any questions from the committee.
Thank you, Your Honor. Judge Williams.
Good morning. Thank you, Chairman Durbin, Ranking Member Grassley, and Senator Coons for holding this hearing today in the honor of appearing before this body. Senator Booker, I believe our ancestors are indeed smiling down on us this morning. Senator Menendez, thank you for your ever so kind words. I have many to thank for the journey that finds me here today. My village is strong and the list is long, but I will be quick. My family here with me, Jim, my husband of 32 years, thank you for all that you do and all that you have done. Our daughter Danielle, who works in elementary education, our son Justin, who works with Hope Scholars. My mother, Millicent Tate, who transitioned from this life in 2004, was the strongest, most resilient woman I have ever known, and the first person to tell me that I was enough, and she showed me and prepared me for the grind. My dad, Norman Tate, who is here with me, the man brave enough to marry a divorced mother of 4, thank you for lighting a new path for all of us. Eton Carver White, also known as Uncle Jimmy, and his family. Uncle Jimmy, thank you for your service to this country and our family. My siblings, Michelle, Diane, Patrick, and Julian, their spouses, and my nieces and nephews. To the Lewis family and all those born McGlashan, all of the cousins who started out on West Street in Jamaica, came through Brooklyn, and landed all over this country. To my in-laws, Jackie, Bonnie, Judy, Andre, Kathy, little Jimmy, my sis, Lisa, and her family. To the sisterhood, my sisterhood known as Alpha Kappa Alpha Sorority Incorporated, for its service to all mankind and instilling that purpose in me. David Jasinski for allowing me the room to develop as an attorney. Finally, the District of New Jersey, my federal family, my court family, my courthouse family, my chambers staff, Nicole, Tiana, and Kara. Shout out to Camden, shout out to the 7 southernmost counties of New Jersey, especially Atlantic County, where I put down my first legal roots. My village is strong, my list is long. I appreciate the patience of this body for allowing me this time.
Thank you, Your Honor. And finally, Mr. Olson.
Thank you. Thank you, Senator Coons and members of the committee. I am so honored to appear before you today as the nominee to be the Assistant Attorney General for National Security. I am grateful to the President for his confidence in nominating me for this position, and I would also like to thank Senator Cardin and Senator Van Hollen for those very kind introductions. I am joined here today by my family, my wife Fern, my 3 children, Elizabeth, Nate, and Will. I would not be here without their love and support. I would also just like to take a moment to remember my parents, Myrna and Van. I was born in North Dakota. I moved here as a young kid because my dad got a job with a member of the House of Representatives from North Dakota. We were going to move back to North Dakota in 2 years, and we ended up staying here for my entire life. My mom was a school nurse. Public service is the most noble calling in my family. Congress established the National Security Division after 9/11 and charged it with carrying out the Department of Justice's most important priority, and that is to protect the nation from terrorism and other threats to our national security by pursuing justice through law. The threats we face today are diverse and complex, and the National Security Division plays a vital role in protecting the nation. I believe that our greatest strength in defending the nation comes from our career public servants. They are dedicated to securing our country with fidelity to our founding values. And if confirmed, it will be my absolute honor to lead and support the extraordinary workforce of the National Security Division. We will confront domestic and international terrorism. We will counter threats to our cyber infrastructure. We will protect our nation from espionage and foreign adversaries, and we will work to foster trust of the work of the intelligence community. I believe that my experience has prepared me to take on this critical responsibility. I began my career in the Department of Justice in the Civil Rights Division as a trial attorney. As an assistant United States attorney, as a federal prosecutor in Washington, D.C., for over a decade, I prosecuted crimes at the state and the federal level. Those included murders, homicides, complex conspiracies, and public corruption cases. I learned to pursue justice based on the evidence and based on the law. And I learned to protect both the public safety and the rights of the accused and all Americans under our Constitution. The terrorist attacks on September 11th changed the course of my career. Led me to shift my focus to national security. I first worked at the FBI as special counsel to Director Mueller, helping to support the transformation of the FBI after 9/11. In 2006, I returned to Main Justice to help establish the new National Security Division. I was responsible for overseeing the department's intelligence work, including the implementation of Congress's landmark changes to the Foreign Intelligence Surveillance Act. I was the general counsel of the National Security Agency, and from 2011 to 2014, I served as the director of the National Counterterrorism Center, which Congress established to unify and coordinate our counterterrorism efforts. At every stage of my career, I've been guided by the values of the Department of Justice: devotion to the Constitution, to the search for the truth, and to the pursuit of equal justice under the law. If I am confirmed, I will follow the facts and I will follow the law, and I will work relentlessly to advance the security of the nation. I look forward to answering your questions. Thank you.
Thank you. Thank you to all of our 5 witnesses of this panel for your opening statements. We're now going to proceed to 5-minute rounds of questioning. As you all know, the Senate is currently in the middle of a vote series. Thus, senators will come in and out, and I presume that the chairman will return and I will go for a second vote. But let me begin. If I could, Mr. Olson, from your opening statement, it's clear you're no stranger to the critical work of the National Security Division. I'd be interested in having you just elaborate a little bit on the time you spent working there previously, and can you explain the critical role that office plays in supporting our national security? And then just elaborate a little bit more on your service working for the U.S. Attorney's Office in the Bush administration and how that experience prepared you for your service in the subsequent Obama administration.
Yes, absolutely. And thank you, Senator. I was there at the very beginning of the National Security Division. I was there at the very beginning of the National Security Division. It was established by Congress because of a recognition that the Department of Justice's various elements that worked on national security, whether that's the Foreign Intelligence Surveillance Act or counterterrorism or counterespionage, were not sufficiently unified. The decision was made to create the first new division in several decades, the National Security Division, which, like a number of other parts of the government, were reformed in response to the attacks of 9/11. In my judgment, the division's been an unqualified success, bringing together intelligence professionals and attorneys who work on applications to the FISA court, along with the prosecutors who handle and oversee counterterrorism cases and counterespionage cases, and really been part of the broader national security reformation following the attacks of 9/11. But I should add that it's also continued to evolve since I left a decade ago. I left in 2009, and it has changed to evolve to meet the threats we face today, whether those threats are from cyber actors, from those that would seek to steal our intellectual property. It has continued to grow and evolve as the threats that we face have grown and evolved, and again, to continue to represent the intelligence community very effectively.
Thank you, Mr. Olson. I think based on your broad and deep service and experience, we're lucky to have you nominated to continue your public service in this role. Ms. Williams, if I might, Judge Williams, forgive me. You've served as a magistrate judge, I think, for 12 years. How has that role and experience prepared you for an Article III judgeship? And what aspects of that new role for which you've been nominated are you most excited about, if confirmed?
So thank you, Senator. For the past 12 years, I have served the District of New Jersey as a magistrate judge, and I am lucky to be in the District of New Jersey, which has delegated quite a bit of authority to magistrate judges in our district. And so most of my work is managing cases and preparing them for disposition by the Article III judges. And so how my work as a magistrate judge has prepared me is to understand the process of judging and justice, and to ensure that everyone who appears before me as a magistrate judge, or if confirmed as a district court judge, is privy to a fair, impartial process.
Thank you, Your Honor. Judge Pan, during your tenure as a magistrate judge, if I understand correctly, you've presided over more than 650 trials. That is an astonishing body of work. You've spent your entire career in public service. President Obama noted your unwavering commitment to justice and integrity upon your initial nomination. I just would be interested in how your experience as a magistrate judge and your long public service dedication will inform your service in the federal judiciary as an Article III judge, should you be confirmed.
Thank you, Senator Coons, for that question. For the last 12 years, I've served as a judge on the District of Columbia Superior Court, the local court of general jurisdiction in the District of Columbia, and I've served in the criminal division, the civil division, and the family court. Before that, I was an assistant United States attorney for 10 years, and so I have devoted the last 22 years to serving the citizens and residents of the District of Columbia.
Didn't seem that long at the time, but when you say it, it seems like a long time, doesn't it?
Yes, well, it's been an honor and a privilege, and I would be honored to continue my service to this same community in this new capacity as an Article III judge, to consider issues of constitutional and federal importance, and to continue my service in that regard.
Thank you very much. My 5 minutes are up. Senator Cotton.
Thank you, Mr. Acting Chairman. Congratulations to you all. Mr. Olson, I remember when you used to come brief Congress as the director of the NCTC, and I always found you to be a sober, reasonable national security professional. Like I say, when Joe Biden nominated you to this position, I thought that was one of his better choices. But then I started looking at what you've been up to for the last 4 years, and now I have questions about which Matt Olson we're getting. In 2017, you wrote an op-ed entitled, "The Electoral College is a National Security Threat." I want to repeat that. The Electoral College is a national security threat. Do you still believe that the Electoral College is a national security threat?
Well, Senator, let me begin by thanking you for your initial comments about my time as the National Counterterrorism Center Director. And I spent my better part of my career as a government public servant protecting the country. I left the government in 2014 and entered as the private sector. I wanted to remain engaged on the issues that I thought were important. And as a private citizen, of course, I expressed some views, including that article you're referring to, in a way that I wouldn't and haven't expressed as a public or government servant. That view, yes, there are aspects in context, if I may explain, there are aspects of the way in which the Electoral College allowed or could allow nefarious cyber actors to pinpoint their efforts to influence an election. There are ways in which the Electoral College makes us more vulnerable to nefarious, particularly nation-state cyber actors to influence elections. And that was what I was seeking to highlight.
I'm sorry.
No, of course.
Our time is very limited here. So you still think the Electoral College is a national security threat?
I stand by the content of the article that I wrote. Yes.
Should the Department of Justice ever bring a lawsuit to try to force states to, say, adopt the National Popular Voter Compact?
Senator, I'm not familiar with any statutory provisions or proposals along those lines.
Last year, in the middle of riots that caused billions of dollars of damage and had murders spiking at rates not seen in a generation, you described the situation as mostly peaceful protests. Do you think the rioting we saw last year was mostly peaceful protests?
I think that I'm not sure exactly the comment you're referring to, but I.
You signed a public letter last June saying that.
Yeah, I will say this, Senator. If I'm confirmed and have the opportunity to lead the National Security Division, the threat that we face from the types of violence that we've seen in the past several years, particularly any type of domestic terrorism, I would be responsible for enforcing our laws and enforcing those laws regardless of ideology and enforcing them fairly and impartially. And that would be my pledge.
You once wrote that ISIS supports Donald Trump. You think that ISIS supported Donald Trump?
I appreciate, again, Senator, the article you're referring to. Again, as a private citizen, I tried to stay engaged on the national security issues that I had worked on. And I will answer your question directly. The article I wrote was based on statements that I had seen that I was very concerned about from a propaganda standpoint. In 2016, when I wrote that article, ISIS had risen and was using its propaganda machine to influence people in the United States, and they were using the language, the words of then candidate Donald Trump to advance their propaganda machine. And so I was referring to their exact words in making that statement. And I stand by the article. I was concerned about the ways in which ISIS was using those comments to recruit and mobilize people in the United States.
If it's true that ISIS supported Donald Trump, do you think Abu Bakr al-Baghdadi thinks he made a bad bet?
I'm very supportive of the nature in which we prosecuted and the way the Trump administration took the fight to ISIS over the past several years.
Okay. So, Mr. Olson, I'll just say again, I had a lot of respect for the Matt Olson we saw as the NCTC director, but I feel like something has changed here. Just in the last 4 years, to review what we've covered today, you've said ISIS supports Donald Trump. You referred to rioting last summer as mostly peaceful protests. You've said the Electoral College is a national security threat. It's one thing to leave government, comment on public affairs, to even be partisan, to give money to candidates of your choice and to campaign for them. But I feel like something about Donald Trump's presidency in the last 4 years sent you a little bit around the bend. So it makes me wonder which Matt Olson we're going to be getting at the Department of Justice. My time's expired.
Thank you, Senator Cotton. Senator Blumenthal.
Thanks, Mr. Chairman. I want to put in the record, first of all, a letter from more than 20 former prosecutors in Connecticut, including 3 of my successors, maybe more, as U.S. Attorney Deirdre Daley, Chris Droney, and Stan Twardy, all of them among the most distinguished lawyers, but also former prosecutors in Connecticut. A rather extraordinary letter attesting to the integrity and intellect of Judge Merriam. If there's no objection, I ask that it be put in the record, Mr. Chair.
Without objection.
Thank you. The reason I focus on this letter is, Judge, because your career has been on the other side of the courtroom from them. And all of the members of this panel who have been in the trenches of litigation, particularly in the criminal area, know how heated and contentious it can sometimes be. So to have this kind of extraordinary vote of confidence in your integrity and credibility, I think says far more than I could about the qualifications that you bring to this position. And there are a lot of things going on today here in the Capitol. The President's going to visit. We have potentially an infrastructure agreement. But for all of us in Connecticut, your appearance here is one of the more consequential events of the day and of this year, because you will serve on the bench for decades, God willing. You may well hear cases of students who are now in law school. And every one of you who will serve on the bench are the voice and face of justice to everyday Americans. Most litigants simply don't have the wherewithal or the time or resources to appeal to the Second Circuit Court of Appeals, and for them, the decisions in the district court are justice in America. So this position is so profoundly important to our nation, and to have someone who, as has been stated by those lawyers I mentioned, has, quote, brought an even-handed and accessible approach to the federal bench, and, end quote, and applied the law fairly and properly without regard to personal preference, end quote, is an extraordinary gift to the people of Connecticut and our country. Maybe if you don't mind, could you tell me a little bit about how your experience as a federal defender has informed your work as a magistrate judge and the approach that you'll take on the United States District Court bench?
Thank you, Senator, for those very kind words. Connecticut has the great benefit of being a fairly small federal court, and it is collegial, and people know each other, and they respect each other. And I felt that as a defender, I felt that as a law clerk, I felt it in private practice, and I feel it now as a magistrate judge. And in the 18 months in which I was appointed as a magistrate judge, 2 others were appointed in close succession. One, a career prosecutor, and one, a career civil litigator. And over the past 4.5 years, almost 5 years, the 3 of us have worked as magistrate judges together, asked for each other's advice, shared our ideas for how to better the system and to better the experience of people that come in front of us. Because as magistrate judges, we are the first person a litigant usually sees. And likewise, for a public defender, you're the first person a defendant turns to when they're caught up in a system that can be very scary. But at the end of the day, I think my experience there helped me to see all sides of this system and to understand that when people come to court, it's because something has gone terribly wrong, and we need to help them get through that crisis with respect.
Thank you. Mr. Rosen, you and I spoke about the 9/11 families when we had an opportunity to talk privately, and I emphasized to you my concern about the government, in effect, withholding evidence and information that they need to pursue their case against the government of Saudi Arabia. And I think the failure to provide that evidence and information is absolutely unconscionable from what I know. I have purposely rejected opportunities to look at the classified information because I want to talk as publicly as I can about what I do know without any threat or hint that I'm violating the rules of classification. But I think the American people deserve an explanation as to why our government is, in effect, withholding or concealing evidence that would aid the 9/11 families in pursuing justice against the government of Saudi Arabia, which may well have aided and abetted the attackers on 9/11 that caused the deaths of their loved ones. And I have written, along with my colleagues, Senators Gillibrand and Menendez, to the Attorney General, Merrick Garland, and Director Wray as recently as 2 weeks ago. Over the past couple of years, I've sent several letters with different groups of colleagues on and off this committee concerning the departments and the FBI's invocation of the state secrets privilege, still without any explanation. I asked Director Wray about this issue in 2019, and I've asked Attorney General Garland and Helene Greenfeld about it earlier this year. The administration so far has provided no explanation or the evidence that the 9/11 families are seeking. We are approaching the 20th anniversary of that insidious, unspeakable act of horror, an attack on our nation. And the American people deserve to know 20 years later why that information still needs to be withheld. You and I talked about it. I know you're not in the job right now, but I would like a commitment from you that you will review this matter and you'll consider whether the privilege has been properly invoked and provide an explanation to the American people.
Senator, thank you, and thank you for the opportunity to discuss this issue with you. As I mentioned, I am in this work of national security because of 9/11. And you have my commitment that, if confirmed, I will work with the Attorney General to review this matter closely.
Thank you. And by the way, on the Electoral College, I agree with you.
I appreciate it.
Thank you.
Senator Grassley?
Ms. Cobb, as a law student in 2004, you wrote an article on federal statutes and regulations. You argued that social history should be used in statutory interpretation, a position that led you to criticize a dissent by Justice Thomas. In criticizing Justice Thomas, you wrote about, quote, the utility of looking at the social and legislative histories in tandem to garner a complete understanding of both the purpose and the meaning of the legislation, end of quote. Do you think that the words in a statute can change meaning based on social events?
No, Senator, and if I could just put that in context, I believe you're referring to an article I wrote when I was maybe 23 or 24 years old. I had never had a client before, never been in court. My role as a judge is obviously different than my academic pursuits when I was in my 20s. I believe that you start with the text. I've never used the...
You've answered my question.
Thank you.
You bet. And I thank you for upfront saying no. Second, do you agree with Justice Kavanaugh that courts should phase out the statutory term alien in favor of non-citizen because of the perceived social history of those terms?
I don't have a position on that, Senator. I've not considered that.
In January of this year, you were a panelist for the Metropolitan Washington Employment Lawyer Association. You spoke at a webinar entitled, quote, Litigating Race Discrimination in Employment in the BLM Era. My understanding, that's the end of the quote, my understanding is that you talked about both racial discrimination and sexual harassment. Will you please explain for us how litigation is impacted or changed by the Black Lives Matter era? In other words, I wouldn't think that movement would change anything from what it would be previous to that, but I'll wait for your opinion.
Senator, yes, I didn't choose that title, and I don't know that it actually captured what was discussed at that informal luncheon discussion. I think a better title, if I were choosing it, would be litigating cases or current considerations for litigating cases. I think that there is a lot more discussion about race, and whether you want to attribute that to the Black Lives Matter movement or anything else, I think people are more in tune to it, and there are certain considerations as litigators. For example, one thing that came up that I recall from that informal discussion was just talking about voir dire. You have jurors that have exposure to what they're seeing on the news and may have opinions that litigants need to flesh out to make sure that we're getting fair and impartial jurors. So I think a better title would be current considerations for litigating race discrimination and sexual harassment cases.
Okay. Mr. Olson, as head of National Security Division, you will supervise the counterterrorism section. I'm deeply concerned, given recent events, that the current administration does not take an even-handed approach to domestic terrorism. For example, we know that the FBI is currently investigating 500 domestic terrorism cases of primarily anarchist extremists that were opened during the 2020 riots. These cases constitute 25% of the FBI's current domestic terrorism investigations, yet they're not mentioned in the administration's domestic terrorism strategy. Two questions. Will you commit to pursuing left-wing domestic terrorism cases in addition to right-wing ones?
Thank you, Senator Grassley, and absolutely. I will pursue all acts of violence, all acts of domestic terrorism, regardless of ideology. That's the commitment that I make. That's the commitment the Attorney General has made.
Specifically, how do you plan to ensure that your division is prosecuting left-wing domestic terrorism cases at the same rate and pace as right-wing cases?
Senator, I was a prosecutor here in Washington, D.C. for 10 years. I worked as a career public servant on national security matters for another decade. My entire career has been based on following the facts and following the law, applying the law to those facts. If I'm confirmed in the National Security Division, that's exactly what I will do. I will follow the facts, investigate every case that falls within my purview without regard to ideology.
My last question is to Judge Merriam. At your investiture, Judge Alvin Thompson said, quote, "I believe that in both her professional life and her personal life, she lives out the ideals of justice and fairness expressed by John Rawls in a publication, A Theory of Justice." What does a theory of justice mean to you?
Thank you, Senator Grassley. I'm afraid I have not read it, and I'm not familiar with what Judge Thompson was referring to.
As a magistrate judge, how does the concept of justice as fairness affect your job, if at all?
Every day, Senator. Every day, it is my job to make sure that every party that comes in front of me is treated completely fairly.
Do you think an effort to achieve justice from Rawls, well, I guess you can't comment on that, so I won't ask that question.
Thank you, Senator.
I'll get you a copy of that book, Senator. This is a transition period. We're going live, as they say, except a couple of the senators are still in a remote virtual situation. We're going to see if they're tuned in. From the great state of Minnesota, Senator Klobuchar.
Thank you. I'm not in an undisclosed position here. I am in the Capitol, but thank you very much, Chairman Durbin, and thank you to our panel of witnesses and I should say nominees. I want to welcome you, Judge Pan, especially back to the Senate with another opportunity to be considered. I know you got out of the committee by voice vote last time back in 2016, and then sadly wasn't considered by the full Senate. But in the years since you appeared before the committee, you have continued to serve as a judge on the DC Superior Court. Could you talk a little bit about the last question from Senator Grassley? How do you ensure that those who appear before you believe that the court can reach a fair and just decision? I think it's very important right now for judges to think about this because the last 4 years we had some politicization from the White House of the judiciary. And to me, that all citizens feel that judges can be fair in their decision-making process is really important.
Thank you, Senator Klobuchar. As a judge on the DC Superior Court for the past 12 years, I've tried every day to make sure that every litigant, every party, every witness, everyone that comes into my courtroom receives fair treatment, open-minded decision-making, and prompt decision-making from the court. I think that that's what they're entitled to from our system of justice, and I'm deeply committed to ensuring that everyone who enters my courtroom receives the highest quality of justice and fair treatment. And we've received training from my court to make sure that this happens, and I try to do it every day. Thank you.
Well, thank you. And at a time where we've seen this horrific violence against the Asian American community, it's critical that our institutions reflect the diversity of our country. And if confirmed, you would actually be, I was surprised by this, the first Asian American woman to serve on the district court for the District of Columbia. Can you take a moment to tell us what that would mean to you personally, to your family, and to the community?
Thank you, Senator Klobuchar. I think diversity on the bench is important because it contributes and promotes confidence in our judiciary for the community to see that the judiciary actually reflects the membership of the community as well. I also think it performs an important role model function for members of the bar who are people of color or from groups that are not traditionally or haven't been nominated to the bench in large numbers. And so I think that that is important. I'm deeply honored to be nominated by the president. I was the first Asian Pacific American judge in the District of Columbia, and it would be a tremendous honor to become the first female Asian Pacific American judge on the United States District Court in this jurisdiction.
Very good. Thank you very much. Mr. Olson, I enjoyed our discussion, and I want to welcome you as an honorary Minnesotan since you were born in Fargo, but spent summers in our great state in Detroit Lakes. You've spent more than 2 decades in government service and national security in numerous leadership roles under both Presidents Bush and Obama. How has your experience in national security from across government and having served presidents of both parties prepared you for your role? And then if you could just comment a little bit about what we talked about the other day, cybersecurity and elections. So thank you.
Thank you very much for that, Senator Klobuchar. So yes, I came up on in working in national security during a time when the Bush administration was in office. And in fact, some of the most consequential work I did in my own view on national security took place during the Bush administration. The transformation of the FBI, the passage of the landmark changes to the Foreign Intelligence Surveillance Act. These were priorities of the Bush administration. I stayed on as a career national security official into the Obama administration, and I think one of the enduring lessons of that experience was that national security really transcends political or partisan considerations. And that's true not just in my own experience, it is absolutely true of the people that I worked with, whether they were in the intelligence community or at the Justice Department. That people who worked on national security cared about protecting the country. They were not influenced, and they refused to be influenced by political or partisan concerns. That would be the way I would proceed if I'm fortunate enough to be confirmed, is to continue to lead the National Security Division according to that ideal of nonpartisan, apolitical commitment to national security. And that's what I learned from that experience. On the second part of your question, Senator, cybersecurity has been an issue for a number of years, but it has really taken prominence in the past several years as a national security threat. And I would be committed to continuing the great work that the National Security Division has done in prosecuting cyber criminals, people who are engaged in nefarious cyber activity that threatens our national security, particularly our critical infrastructure. There are nation states, particularly the Chinese or China, that is involved in stealing our intellectual property, carrying out espionage through cyber, and the National Security Division plays a critical role in countering that activity. And that's something I think that's going to continue to be a priority going forward, and I look forward to, if confirmed, being able to work on that further.
Thank you. Thank you to all the nominees.
Thank you, Senator Klobuchar. Is Senator Ossoff with us?
Yes, I am. Thank you, Mr. Chairman.
Take it away.
Thank you, and congratulations to these nominees on your nominations. Mr. Olson, my first question is for you, please. Despite serious problems documented in the FISA application process by the Department of Justice Inspector General, among others, the Foreign Intelligence Surveillance Court approved electronic collection activity in response to all 459 of the final filed government applications requesting such authority in 2020. Given the deficiencies that have been identified by DOJ's Inspector General in the FISA application process, are you open to and will you work with this committee to develop possible legislative fixes to ensure the integrity of the process?
Yeah, Senator, the direct answer to your question is yes. I look forward to working with this committee in continuing to improve the Foreign Intelligence Surveillance Act and its implementation. If I may just say, it is a landmark law. It has provided, as a tool, indispensable intelligence to protect our country. At the same time, I was very concerned by the findings of the Inspector General in its recent report on the deficiency in the way that the law has been implemented. And I am absolutely committed. It would be, in fact, a priority, if I'm confirmed, to continue to work to address those deficiencies and to improve the process, because the trust of the American people depends on their confidence in the way that law is implemented.
And you acknowledge that the remedy to those documented flaws may include legislative fixes, and you're willing to engage in good faith with this committee to consider such fixes?
Yes, of course, working with the rest of the Justice Department and the intelligence community, with this committee and Congress, to implement those changes. I've done that in the past, and I would do so again.
Thank you, Mr. Olson. And in your position, you will have responsibility for reviewing all applications for surveillance under FISA. Is that correct?
Yes.
Based on the department's disclosed FISA statistics for 2020, you personally would need to review and fact check at least one 25-page document every day in order to personally render such oversight. Can you please describe the process that you anticipate you would implement by which you would assess the accuracy of facts stated in applications to the Foreign Intelligence Surveillance Court?
Yes, of course. And so, Senator, the National Security Division includes, when I was last there, approximately 100 attorneys who are responsible for appearing before the FISA court, representing the government before the FISA court, and working with the intelligence community, particularly the FBI, to review those applications. Ultimately, they go to a senior official, whether the Attorney General, the Deputy Attorney General, or if I'm confirmed, me in the role as the Assistant Attorney General for final signature. The crucial point here, of course, is that the process needs to be sufficiently robust so that facts are checked and documents are reviewed by agents at the FBI, for example, who submit these applications, by lawyers at the FBI, by lawyers at the Department of Justice, by the individuals who support the judges. So there's a multi-layered process to check the facts and to ascertain the lawfulness of any application, that it meets the standards, in particular probable cause standard, before it's approved by the FISA court judge. Again, I was very concerned by the IG's finding of 17 significant problems in a number of applications that the Inspector General reviewed, and I know that there are a number of steps already underway by the FBI and DOJ to address those concerns, and I would make it a priority to ensure that those are implemented.
Thank you. And Mr. Olson, you will take personal responsibility for ensuring that all applications to the FISC are factual and accurate?
Yes, Senator, that is part of this job, is to be personally responsible, in my view, for the FISA court process and to represent the government in a way to ensure that FISA court applications are complete and accurate.
Thank you. Section 702 permits the government to obtain the content of communications between Americans and foreign surveillance targets. This, sometimes referred to as incidental collection of American communications, can sweep Americans into surveillance without warrants from courts other than the Foreign Intelligence Surveillance Court, and some would argue this deprives them of Fourth Amendment protections. What are your views on the scope of this incidental collection and whether or not it does pose a threat to the privacy of American citizens?
Senator, in my views, Section 702, first of all, has proven to be extraordinarily successful in collecting critical intelligence that's focused on non-U.S. persons, non-U.S. citizens who are outside the United States, and has been upheld numerous times by courts that have reviewed the way in which Section 702 operates with judicial and congressional oversight. The concern that you raised is an important one. That is the privacy concerns or interests that are implicated when a U.S. person their communications are captured in the course of targeting a non-U.S. person overseas. And the key here is that there are procedures in place to destroy that information if it does not involve foreign intelligence or evidence of a criminal act. I would say that there have been a number of cases where that, as we've referred to, incidental collection has led to important foreign intelligence also being collected. For example, if a target outside the United States is communicating with a co-conspirator inside the United States, the government has identified that co-conspirator inside the United States and then been able to follow up appropriately under the Fourth Amendment to continue that collection. So the law, I think, strikes the right balance. That said, we need to be careful and sensitive to the privacy interests that are certainly implicated by the way it operates.
Thank you, Mr. Olson. I'll have additional questions on this subject for the record. And if indeed you are confirmed, look forward to working with you. Thanks for your testimony. I yield, Mr. Chairman.
Thanks, Senator Ossoff. I think I'll be the last to wrap up, and I just have a question for the aspiring judges. And it relates to my own experience here serving in Congress. It was about 30 years ago when we declared a war on drugs. And the reason that we acted as we did had a lot to do with the advent of crack cocaine. The arrival of this new narcotic was scary. It was very cheap, very addictive, and very destructive to many people. And during the course of our debate on this issue, I was in the House at the time, there were incidents that occurred that gave us a sense of immediacy, all the discovery of this drug and such. There was a case that did not involve crack cocaine, but had a great deal of publicity involving a Maryland basketball player, Len Bias. And as a consequence, we did something dramatic. We created a sentencing guideline for crack cocaine at 100 times the level of powder cocaine, 100 times. The idea was that if we came down that hard, that fast, that dramatically, that it would really break the back of crack cocaine in terms of its infiltration into America. We were completely wrong, completely. The number of addicts increased. The price of the drug on the street went down instead of up, and we started filling our prisons, primarily with African American defendants. Dramatic increases in our federal prison population to levels we'd never seen before. And some of the sentencing that went on as a result of it, we look back on and say, how could we have done that? A man named Alton Sims in the Chicagoland area. 3 nonviolent crack cocaine sales. Life in prison. Life in prison. And many others just like it. They went way beyond any deterrent effect and really reflected our desperation to bring this under control. Many judges commented as they were forced by our mandatory minimum sentences and other guidelines that they didn't feel justice was being served in their courts when they imposed these sentences. I knew several of those judges personally who talked to me at the time. Since then, I've tried to correct my mistake, and we have passed 2 reforms of the sentencing law. Senator Grassley was my partner in the most significant one, the First Step Act, and fair sentencing before that. I'd like to ask the 4 of you who are aspiring to these district court judgeships, what lesson we should have learned from this experience? Judge Pan?
Thank you for the question, Senator. I think that you raise a question of deep significance that affects many people. And the lesson that I've learned from what you've just said is that the legislature can learn from mistakes and seek to correct them through the legislative process. And I think that's a very positive thing for the legislature to undertake. Of course, as a judge, this is not the kind of thing that we can address as a policy matter. But I think sentencing considerations before judges are done on a case-by-case individual basis, and we are required to look at the facts of each case. But from a judge's perspective, I think that making the sentencing guidelines no longer mandatory and now voluntary is another thing that's been helpful in this regard.
But there are sentencing enhancements that are suggested by the government in many cases. Does that come into play? That's a discretionary decision by the judge.
Yes, and of course, as a judge, performing the function of sentencing, which is so important because the liberty of another person is at stake, a judge must consider all of the relevant factors, including the requests of the government, and weigh all of that under the totality of the circumstances.
Judge Williams?
Senator, my understanding of how, as a judge, if confirmed as a district court judge to deal with it, is informed by my handling of some misdemeanor cases, squarely not on point with addressing the crack cocaine issue. As I agree with Judge Pan, that's an issue for the legislature. What we have learned, what we learn and know as judges, is that we have guidelines to follow. 3553A allows judges to interact with a very, very seasoned and skilled probation office that helps inform and supply us with the information necessary for us to work through those guidelines on individual cases. So I've done that in misdemeanor cases for individuals charged with crimes, and should I be confirmed, I look forward to working with our many talented probation officers as I work through the Sentencing Act in the role of sentencing as a district court judge.
Judge Merriam?
Thank you, Senator. When I was in the Federal Defender's Office, I was there when the initial changes in the crack powder disparity went into effect, and I was heavily involved in the process of organizing the district, which meant everyone. That was the prosecutors and the probation office and the judges and the marshal service and the defense bar to make those changes applicable to the clients where it was appropriate, as quickly and efficiently as possible, to try to do the justice on the ground that the legislature had seen fit to put in place. And those changes have certainly made a real difference over the years. But at the end of the day, we're bound now, other than by the mandatory minimums, by 3553A, which is, as Judge Williams referenced, very broadly encompassing the kinds of factors and the kinds of considerations a judge can take into account. And that discretion is an awesome one and an important one, and allows judges, I think, to work within the law to try to do justice.
Ms. Cobb?
Thank you. It's hard to improve upon the responses that have been given, but I think what struck me most about what you said is the fact that this body was paying attention to what was happening in the courts, and I think that's extraordinarily important. When laws are passed, particularly that provide criminal penalties, whether they be mandatory minimums or otherwise, to pay attention to kind of what the effect is on the ground once those laws are implemented. And I know that the Sentencing Commission does some work in compiling statistics, but I really think it's important to, continue to pay attention to what's happening after these laws are passed.
Let me just add one other thing that has changed the conversation. 20 years ago, 15 years ago, if you would have said, oh, did you hear about that person who overdosed on drugs last night? The most common answer would be, no, I didn't. Was it an African-American, inner city, man between 20 and 35? You would have been right in most cases. Not anymore. When we talk about drug overdoses now, it could have been that cheerleader at the all-white high school in the suburbs. And drug addiction has now reached every corner of America. And we're starting to look at it anew. It is no longer just say no. We realize it is a medical problem, a disease. We haven't responded with the adequate resources to deal with addiction. I hope we will in the future. But the conversation on drugs has changed in America because the victims have changed pretty dramatically. That is going to be part of the reality that I hope you soon will be dealing with in your new positions. I thank you for your cooperation at this hearing. It's been an important one. You may receive some written questions in the near term. Is there anything else I need to do formally? Wants me to read it, make sure you understand this. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, July 21st. The record will remain open until that time to submit letters and similar materials. And with that, the hearing is adjourned. Thank you all very much.